United States and Australia are sister lands. All around the globe, we are holding hands. Plymouth Rock to Botany Bay, colonists hope for a better way. Sydney Opera House to Broadway, a testament of who we are today. And we both still have rent to pay. We still have rent to pay. Aintree Park to Honolulu, Utah Arches to Uluru, Bourbon Street Jazz to didgeridoos. Our kinship is deep and true. This is how we begin to start atoning for our sin, by creating new expectations for our blemished nations. The Great Barrier Reef to Grand Canyon, from the Everglades to Billabongs, the Cloud Queen cares about everyone. The roller coaster ride is only just begun. Cry, debunk, demystify, destigmatize, uniting USA and us. Uniting USA and us. The world is her battleground, her global roller coaster goes around, calling all nations with her horn. She is a shooting star out of Melbourne. Miss Shorty is a shooting star out of Melbourne. Shorty connects and unites, debunking all the lies. She leads us in our fight. She's a fucking delight. Grizzly bears eat hikers who are in a rush, and Aussie dingoes steal babies in the bush. The damn beavers live in the brooks, and so does the weird-ass platypus. From Bondi Beach to Miami, Adelaide Hills to Napa Valley, from Kosciuszko to Colorado snow, Lady Gaga to Kylie Minogue. Miss Shorty connects and unites. Our citizens should be made right. She leads us in our fight. She's a fucking delight. This is her cry. Debunk, demystify, destigmatize, uniting USA and us. Uniting USA and us. The world is her battleground, her global roller coaster goes around. A shooting star out of Melbourne, calling all nations on her bullhorn.
It worked. Adam, you're a genius. Love ya. Hi, shorties. Ernie, Adam, me. Oh, and there's a couple of lurkers. Who else is here? Welcome, lurkers. Welcome, welcome. Hi, I'm Shorty, and this is Poppy. Standard. There's Poppy, and there's Buster. Hey. Hey, so we've got another episode of Florida versus Donna Adelson. I just made my first short in the longest time. Donna Adelson. I can't play it on stream because it's got music in it, and I will get a copyright strike. And Laurie, hey, see, yay, Laurie's here. Russ's here. Oh, Adam's saying hi. He's such a good moderator and friend of boyfriend. Poppy, you're not a good dog. All right, so we left off yesterday. Don't forget to hit like, share, subscribe. I hope all of you in here are subscribed. Hey, there's 8 people now. Cool. Thank you for coming. Hey, Ernie. And he says hi to Laurie. We're a family, right? Camp Shorty has continued. What are you doing licking her? These dogs, right? What are you doing, crazy? She's like this all the time. Seriously. Okay, anyway, I'm a professional. Oh, hi. Welcome, welcome, Ruby G. Thanks for coming. So we got my earbuds in still. Wait, I'm going to take them out, and then it's going to mute me. And I'll leave them in. I forgot. I'm doing professional stuff. Lol. So in the description box for this episode, I've linked last night's episode, which was a bit of a rundown on the Dan Markel, Donna Adelson, Wendi Adelson, Charlie Adelson, the whole kit and caboodle. And then we started going through the couple of the most recent pre-trial motion hearings, which happened about 2 weeks ago. So we did that. Hang on, wait. I'm a professional. See, I really am. And so we quit that about just under 2 hours in to about 10 or 15 minutes before the end of that first hearing last night. So if you haven't seen that episode, jump back in after this stream and catch up. It's kind of cool. Exciting to see Georgia Kappelman again because, Georgia, we love Georgia. I'm going to do one here, but I can't hit it. And Dan Rashbaum, the defense attorney. The second chair is, his name is Attorney Morris, Alex Morris. I checked today. So we know that now. Donna's looking a little ragged these days. Fair, she's 74 and she's been in Liam County Jail for the last 10 months. Sucks to be Donna. I guess that's what happens when you murder someone, right? Oh, yes. General stuff. Well, I know mostly everything about it. It's my special interest case, more than even Karen Reid, if that's possible. So, oh, Luby, you're from Melbourne. Yes, maybe you can come to the next Free Karen Reid standout in early November, 10th of November. Locked in now. Sorry, puppies, guys. So, I've also got a pretty long 86 shorts. Well, it'll be 87 now because I just made another one. Busted, Jesus Christ. Sorry, blasphemy. Playlist of many of the mic drop, epic, hilarious, mic drop moments from from Charlie Adelson's trial, which was he was convicted in late November last year, 2023, of first-degree murder and conspiracy to commit murder for the murder of Professor Dan Markel in Tallahassee in Florida on July the 18th, 2014. It's been a long time coming. So I went into all of that last night. But if you have any questions, drop them in the chat. I can answer them as we go. So pre-trial motions, as I said last night, are pretty much where the work is done in trial. South Morang. Cool. Not far at all. Excellent. So this is where, all the stuff that we all know about as not jurors, this is where all those decisions are made in the pre-trial motions as to what's going to end up getting to the jury, to the fact finders, and how much is allowed in, what's considered opening the door if attorneys ask certain things, that opens the door for certain things that may not have been admissible before, but if they don't tread carefully enough, they will end up opening the door so that evidence can then come in, or that testimony. So Georgia Kappelman is the state prosecutor. ADHD. So in the description of this video is a link to last night's episode and also the playlist of all my shorts. Good times. That's my whole channel was built on those shorts, really. So it's my baby. And as I said, I just made another short. It's kind of cool. It's already had 300 views in about half an hour. So yay. Don't think I'll ever hit the 2 million that I got on one of my shorts, which is ironically called 2 million. Oh, check it out. Actually, maybe Adam. No, I'll put it as a separate link in the description box. It's so cool. It's got 2 million and 50,000 views. I got about 2,000 subscribers from that particular short. So I know my numbers look impressive, but it was all from one short. Bloody good short. Just one of those perfect combinations. It was palatable enough and not niche, not too niche that it appealed to a very broad audience. It got into the algorithm, took off. It was the most incredible thing to watch. It was like gambling. I'd be watching my phone, just watching hundreds of thousands of views in a day. wild. So if anyone ever challenges me that I'm not proper, I'll be like, well, I'm not, but I did get some lucky some lucky hits there. So yeah, Ernie, Donna getting caught in the jetway was so exciting. I said it last night, but I was actually happened to be Shane watching Surviving the Survivor at that time. And when that happened and the breaking news, so crazy. So let me see if I can do this. Wait, I could do it yesterday. Yeah, Bobby, are you going to help? It's not very helpful. Are you happy? Sorry about all the mess on the floor. That's all their toys. They're animals. They're savages. You're like my hoodie, introvert but willing to discuss true crime. I got it from The Shaming of Jay. I don't know if he's still got his shop up at the moment because I tried to link some of their merch in one of my earlier live streams and he told me that they had taken their shop down for the moment while he sorts out his finances. But pretty cool. All right. Auntie Bev, God, thank God there's no Auntie Bev. Judge Everett is so lovely. Oh my God, I love him. He's the presiding judge over this. Probably can you please not? Sorry, Blair, the Blair Witch of it all. All right, let's go. Let's go. LFG. Share screen. So I know what I'm doing. Ooh. I think it's this one. Yes. So I know what I'm doing here. I really do. Thanks for being here. I'm so happy to have you all here. Seriously. So this is where we were up to yesterday.
All right, let's move on to.
Tell me if there's an echo. There shouldn't be because I've got earbuds in. All right.
Reserve ruling as to those sub-prongs for them.
Thank you.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay, and it's certainly not in furtherance of a conspiracy. This is after his conviction. So we're only talking about, let me be clear, we're only talking about jailhouse recordings after Charlie Adelson is convicted. So there are recordings in this case that I believe the state intends to use. I don't know, where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. There's an exception to the hearsay. It's not hearsay. But Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy. And some of the statements are inflaming.
Are any of these in any way tied to this issue of travel as consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think there are statements where Charlie is talking about his trial, and Charlie is talking about why he believes he was convicted, and Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using, but Charlie's statements are not admissible.
Right, state response.
These are statements against interest that are made by Donna Adelson or
Love Georgia.
are adopted by
Love
Donna
Georgia.
Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter of what you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think Your Honor will know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where
This is
Charlie
under the loan application.
yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show like, this is what's happening. It's a call where he's dropping off. She's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
That would probably be best before I rule on this.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction as it relates at least to law enforcement in a defendant's interview. Is your argument essentially this goes to the context?
So Laurie, Charlie's already been convicted, so he's already he's been someone. Ducati girl, do you know where Charlie is now. He was transferred upstate, somewhere else, out of Florida for his safety, I think. But he's been transferred back to Leon County Jail now, awaiting his taking the stand in his mother's trial as a prosecution witness. Oh, I wonder if he'll flip. I don't think so, but we can hope. But so this is only one defendant, Donna Adelson, in this trial. And so it's just her and her two, yes, South Dakota, there you go. Just the one defendant. Donna's more than enough, trust me. Ugh. And so they're talking about I think they're talking about the call where Donna had the ultimate boomer hot mic where she forgot to press end on the call and continued to talk. So this isn't hearsay. This is incriminating statements made by the party opponent. So that's made by Donna Adelson. She's opponent to the state. So that's that. Look at me knowing all my law stuff. I love this shit.
Next on the call.
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well. I'll need to review these calls before I can actually make a ruling on, because as the defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problem.
So Ernie, two hitmen were hired so Charlie Adelson. Wendi Adelson was married to Dan Markel. They got divorced in a very contentious and bitter divorce. They were well and truly divorced, and there were child custody and relocation issues. It got very bitter. So initially, the Adelsons, as a family group, offered Dan Markel $1 million to allow Wendi to relocate from Tallahassee to Miami. He declined the offer because it was very, very bitter. They were going all in from both sides, just hardcore custody shit. So when he declined that offer, they figured, and Charlie is an absolute playboy. He owned a Lamborghini and is a periodontist, dentist. Calls him his number plate on his Lamborghini was the Maestro. He's an absolute wanker. Thinks he's king shit. Mummy told him he was king shit all his life. Donna, mommy. So he was dating all of the hoes, like, with all due respect to Katie Magbanowa, who he dated. Within a couple of weeks of him dating Katie Magbanowa, he asked her if she knew anybody who might be able to rough somebody up, and she did. Her baby daddy, Sigfredo Garcia, was best friends with the head of the Miami Latin Kings, Luis Rivera. So she asked her baby daddy, and because they were broken up, but he wanted to do anything to get Katie back, so he said sure. And the deal was that these two hitmen would drive from Miami to Tallahassee. They were given an address and I think a photo of Danny. Don't quote me on that. They went once and had a failed mission, including, like, they coked up, these two, like, just drinking and coking it up and not taking their task particularly seriously. No, he's bothering. That's what we're looking at now. Sorry, yeah. But so anyway, so basically two hitmen. They tried once, failed, including on the way back from the failed attempt, shooting a hole in the rental car with the gun, just fucking around with the gun, shooting a hole through the fuel line. They had to, you can't make this shit up. So anyway, they went again and they followed Danny home from the gym, went to the gym, followed him home, pulled up behind him as he pulled up in his driveway. He was on the phone to someone, a music teacher for his prospective little two sons' new school that they were thinking of attending. And so while he was on the phone, he said, hang on, and there's someone here. And they shot him twice in the head. It was actually Sigfredo Garcia, the baby daddy, that did it. Luis Rivera was just the driver. But anyway, so that's who did it. And it took a couple of years for the police to make the connections, to start the ball rolling, to properly find who was responsible. But here we are now. 10 years later, the walls are falling.
Problems, and we have relevance problems. Ultimately, I assume anything the state would be seeking to admit is going to meet a relevance threshold. From there, whether playing the entire context of it would otherwise get over the hearsay issue, that I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context in a recording. I will read the sample instruction to the parties. You also may propose any suggestions if it is admitted. But ultimately, it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of the defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You are not to consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses. That ultimately, if any will be admitted at all, that will be subject to that instruction to the jury. So it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. All right? Last prong, autopsy photos.
So, Judge, the Florida Supreme Court has held that autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay. In this case, there is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I might be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 X-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that, again, I think it's a balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
no, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
We haven't done that in the past, but we're also we don't intend on attacking his credibility when it comes to how the murder was done.
State, you may respond.
Judge, this is a material issue that the state's required to prove that the victim is in fact dead. We don't have to accept a stipulation. The photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were X-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the stippling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Very well, as to this point, I will find that the value of autopsy photos are probative and the prejudicial effect does not outweigh them. The motion is denied as to this particular point. Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
Wait, I thought we did this yesterday.
So, Judge, I think our motion to some degree speaks for itself. In this case, the state went to tremendous means to try to wait to arrest Mrs. Adelson until she tried to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in Florida.
Mhm.
We were unable to find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again.
No.
I think we beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know. I'm far.
Adam, he's so shifty. He's like the slimiest of slimies. Well, probably there's more slimy defense attorneys, but Laurie, because he is shifty. That's it, Laurie. That's it. I think he's sucking up hard. I think he's getting a bit big for his boots. Donna rehired him, as in she retained him after he was Charlie's attorney. That didn't work out so well. I don't know. I might have gone for a different with a different attorney, but he knows the case intimately and he knows the defense theory of extortion, not paying for a hitman. Lol. But he's more emboldened than he was in the first trial. He has more confidence. He was just a little baby bitch boy in the first one. He had no idea what he was doing in Charlie's trial. He floundered a lot. It was before I even knew how to make shorts, but I've got a short video on my channel in that playlist, and he's trying to say something to the judge in one of the pre-trial motions before Charlie's trial, and Georgia says, "I can't help Mr. Ashbrown with his strategy." Fucking hilarious. Too funny. So he is far more, I don't know whether he thinks he's looking smooth without his little goatee, his scruffy little goatee he used to have. I think it's probably the $1 million+ in his pocket now, yeah? Yikes.
Far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity? In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases. There's a couple cases that I cited. And here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers.
Hey, Mooney.
Okay, you're going to see that to make sure that she wasn't committing a crime. You're going to see that she used her own passport. You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to
Dan, Rashi, may I put it to you that perhaps she did all those ridiculously foolish things is because she is entitled and she felt untouchable, as the whole family did. These are not transparency issues. These are untouchable issues. She thought she was untouchable, and Rashi advised her to try and flee. Lol. Not even kidding. You cannot make this shit up. Yeah, she should have at least bought a return ticket. They bought a one-way ticket. Lordy, Dordy.
To Mexico or fly to San Antonio, walk across the border, go. You're going to see that everything was pretty open and notorious, things that would contradict flight. And so,
let me stop you there.
Yes.
Does flight have to be surreptitious?
It doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances. When you're determining whether it goes to consciousness of guilt, flight is a component, right? If for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight.
Oh my God, I can't believe how different he is to Lally, right? At least he's entertaining. At least, and this trial isn't going to be that long. I think the prosecution of the state has said that they estimate about 6 or 7 days once opening statements have begun for them to present their case in chief. And then, God knows, Donna will absolutely take the stand. Actually, I should make a poll. I don't know if I can do that. Let me see. Anyway, I'll play around with that because let's do a poll. Will Donna take the stand? Don't answer yet. No one's in the chat. Adam.
When you look at the totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say 7, after she's a suspect, you see that she's traveled many, many times and always come back, right? So, and by the way, you hear phone calls, their phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going and what she's doing, right? And so, look, consciousness of guilt is a very, look, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions. But I'm here.
Well, is there any other evidence that puts context on this travel?
Is there any other evidence that puts context on this travel? I'm not sure I'm understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things that otherwise go to, this is not just the purchase of a flight?
Sure. There are pieces of evidence that I believe the state intends to try to admit that would show both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that. One moment.
Sure.
Yeah, I will. There is evidence of that for sure. But again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and what's the actor's name?
Harrison Ford.
Yeah, Harrison Ford running around in Southeast Asia for the rest of their lives. But we think that when you do your balancing test, prejudice outweighs. We'd also say this, and this my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. But that Vietnam villa is an investment done, as they know, they've spoken as their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it. That villa.
That's under the rules of Vietnam.
No, it's like a timeshare. So even when you own it, you can only live in it for 6 days. And so when Charlie Adelson is arrested, Donna Adelson and Harvey Adelson continue to make payments for that villa because that's the agreement they have with Scott Radius. And if not, they lost the prior payments. It leads to, look, this consciousness of guilt argument leads to a lot of nonsense, to be honest with you. And we think that when you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it's allowed in, we'll probably ask for some sort of limiting instruction.
It's 100%
but Judge, we think that it does fit, the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails.
State.
Judge, there are just as many factors that suggest that this was or flight was a matter that was demonstrating consciousness of guilt as the ones that they plan to argue. She was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. State feels that's relevant. If it's anything that the defense wants to argue and the facts that they've pointed out are they're fair game for cross-examination. They're free to elicit those, and we can have a dispute. Let the jury decide what the evidence shows and what the weight is rather than the admissibility. But how is it a 403 problem if she's just going on a vacation and that's what they're going to show? And what's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
As to this motion, I am prepared to rule. I review the cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. The motion is going to be denied. I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt.
I feel like if you're Googling, and maybe Lally would decline this as being evidence of consciousness of guilt, but I think probably Googling countries with non-extradition treaties is the last. It is absolutely not a holiday research. Yeah. Sorry. Hey, Pierre. 2 hours to deliberate. Wasn't it a little? Is that what you're going to vote for, Ducati girl? Poppy, I love you, but no. Adam, we need to work out how to do a poll. Boy, I need to be able to do polls.
Really, it's not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that the defense would seek, you may submit that concerning this issue. Right, I believe that covers the defense motions for today. Mr. Rashbaum, if you can submit orders, at least for the matters that have been ruled upon concerning these matters. Let's move to the state's motion in limine. As to prong 1, Ms. Kappelman.
Yes, Your Honor. As we have done previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts.
He's on Australian time now, Annie.
And bad character evidence. Did you want me to just address prong 1?
Just prong 1 for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor. I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong 1?
Well, I mean, I think we're going to have to bring up the Latin Kings. I mean, they inserted it. We weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with a gang, did it not? It's just the name Latin Kings wasn't used?
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings is a relevant fact. That was actually inserted by the state in their bump operation, right? The whole point of the bump is someone's approaching Mrs. Adelson, who is supposedly also a member of the gang, and is speaking on behalf of Mr. Rivera, who wants to get paid, right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, how many rapes he's done,
So the name is the identifier, that is what you're seeking to make use of.
Of course.
Ms. Kappelman, response as to the use of the name of the group.
I do not agree that the name is in the evidence that the state intends to produce. If that's Your Honor's ruling, which we would request, then criminal street gang could be substituted for Latin.
Good. We would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Miss Adelson hears that the guy,
As one gang has greater credibility than the other?
it certainly does in Miami, right? So when this.
Yes, Laurie, it is 1 p.m. on Sunday. So I guess we could say that's almost Monday. Ugh. Peasant work shit begins in T minus 7. I start at work at 6:30 tomorrow. Yuck. I love
Miss
it.
Adelson hears that the Latin Kings are behind this. I mean, that's what she hears at some point. That's what the evidence is going to be. It affects how she does certain things, right? And so, we think that is relevant and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also, once again, permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve willingness that specifically, again, in what context beyond hearing she knew he was a gang member, are you planning to use this or present this to the jury? Mr. Rashbaum.
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this was a particular chapter that he was in charge of. Is that what you're getting at?
Correct.
Ms. Kappelman.
Judge, we just think it's prejudicial, more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin king. She knew there were gang members that were threatening to kill, is what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin king.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin kings, I'm going to reserve on that issue for now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin kings in it, we will approach.
Correct.
Thank you.
States prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kaplan.
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred. So I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
Response?
We don't plan on doing this unless something crazy happens in court. Then we'll approach Your Honor and we'll discuss it then. But we don't plan on proactively helping us in trial.
Very well. Prong 3 is granted. Counsel for defense is directed to alert the court should he believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor. We've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kaplan, you may make your argument.
All the prongs. All the prongs. We're here for the prongs.
Yes, Your Honor. The state has prepared demonstrative aids, which combine video footage, clarified audio recording, and transcripts into one item that we'd like to present to the jury for both the Dolce Vita recording as well as the Matt Suri recording. Those are mentioned in paragraphs 4 and 6. We also have similar to what we've used previously with the wiretap calls, slides that have this rolling transcript along with a photo of who's speaking, which we think assists the jury in understanding those items of evidence. I think that was all that was covered in these. Yeah, so Dolce Vita, Matt Suri, and those wire calls. We did previously have an objection to any editing, any underlining or any highlights, which we have removed from those exhibits. So this will not be present.
No response?
Our position is the same as in the last trial. We don't object to the transcripts from the wire. We do object to transcripts for Dolce Vita and Matsuri due to audibility. And last time I think the judge ruled with us and ruled that the transcripts would come in for the wire, but not for Dolce Vita or for Matsuri, and that's our position today as well.
I reviewed the recordings of both Dolce Vita and Matsuri once again. The issue that I keep coming back around to on this, Ms. Kaplan, is ultimately for a recording that does have some limitations or issues. How does the transcript not otherwise suggest the person or I should say jurors who need to listen to and interpret it, what is on the recording if they themselves are not able to make it out clearly?
We do have and had in the last trial as well the authentication of the transcript by a party who was present for the conversation. I think that's what made the difference in reference to the Dolce transcript use in the last trial. We weren't able to use that. Matsuri was out, the defense is correct on that. That could potentially
is that witness going to authenticate then the transcript itself?
Yes, Your Honor.
Mr. Fausch, do you have any remaining argument concerning this?
Yeah, you still can't hear tons of the transcript, and they're guessing as to words on tons of the transcript, and you still can't hear the first 31 minutes because they didn't record it. And they have a recording of those 31 minutes, but they didn't include it. So it should be, look, the standard is in situations like this, you leave it up to the jury to hear what they hear. We're actually not moving to preclude the audio, we're precluding a transcript, right? The law is pretty clear that it's up to the jury to hear what they hear and make a decision based on that and not what the state thinks they hear.
I agree with you, that aspect is clear. The additional portion of the witness who will swear that the transcript is authentic, what is your argument to that?
But every other word of the transcript is unintelligible. UI. So, I mean, that should not come in. You can hear some of those UIs. They're, sure, I can cost the witness, but do we really want to go through that when it's very easy that they just hear what they hear? That's the default.
Very well. This will be granted in part and denied in part. As to any transcript for Matsuri, which there is no authentication available by any witness, that transcript will not be presented to the jury. The jury is to determine for themselves what they believe the recording holds. As to any use of transcripts as a demonstrative with the wiretap calls, that will be permitted. As to the use of any transcript relating to Dolce Vita, that will be subject to a proper foundation and authentication being made by the witness. The defense may challenge the foundation and authentication by the witness. However, if the proper foundation is laid at that point.
Melissa, what's RX? I should know that. What is RX? RX. Darlene, Rashi's tight jacket. Are you hoping it falls off him? Ugh. Melissa, what's an RX? Which transcript is this? Matsui, I think. They want to put a transcript with the Harvey and Charlie conversation. Prescription? That's okay, Laurie. Thank you for coming, and maybe catch the replay. We'll be up to speed. Wendi starts on Monday. Prescription. Thank you, y'all. Meds. Yes. Yes. I love to learn things from you guys. Thank you, RX. Yes, Laurie, come join us whenever you can. Catch the replay when you can. Thank you for joining us. Good night, sweet dreams. For when you fall asleep. Don't dream of bloody Donna. Ugh.
This is no longer guesswork as it relates to the transcript. The parts that are unintelligible cannot be misrepresented in any way.
Tiff!
May not misrepresent the parts.
I didn't even see. Hi, Tiff.
However, to the extent the witness can
Adam,
say,
can you please
this
drop
is
Tiff's
what was
link in
said
the
during
chat?
meeting, that is a proper foundation basis for that testimony, for that evidence to be presented to the jury. That is the ruling as to that item. All right, let's move on to states. Prong 8, statements to elicit sympathy for the defendant.
Yes, Your Honor. We had a prior hearing during the pendency of this case where some issues came to light regarding the defendant's allegations of how she was being treated at the jail. I've conferred with the defense on this. He's advised they do think that that type of reference and material would be admissible in this trial. As such, I would move to exclude any reference to the conditions in the jail as irrelevant under 401 and basically just being offered to inflame the sympathies or passions of the jury and more prejudicial than probative under 403.
What would this be offered for by the defense?
I don't plan on offering it. It depends what comes up at trial, right? So, including consciousness of guilt, because it goes into why someone might do what she did to avoid being in jail, waiting a trial, right? So again, I don't plan on doing it. We don't plan on doing it openly, and we would come to you before we did it, but I didn't want to agree to it because I don't know what's going to come up at trial, right? So it's certainly not going to be something we do without notifying the court first, and I don't expect to do it.
Well, as an important proposition of law, jail sucks. However, why it would become relevant that jail sucks, that's really the question.
I don't, again, as I stand here today, we don't plan on doing it. But if we think it becomes relevant, we'll certainly bring it to the court's attention before we do anything like it.
Very well. Prong 8 is going to be granted subject to any proper relevant basis in which this evidence could be examined upon. Counsel for defense at the appropriate time will need to raise why they think a relevant basis has occurred, and ultimately a proffer will be taken as a present to the jury. And I think that takes us through everything for this morning, other than the other outstanding motion involving Sergeant Corbett, or any other motions being anticipated by the defense or state concerning the exchange of witness list exhibits.
That did happen, Judge, and we are still in communication about small changes that are happening, and we'll bring it to your attention if we have any issues. But so far, we're getting along okay on exhibits and witnesses. There's still a couple depositions outstanding, which we're working on, so no issues to report at this time. We do want to approach on one other matter, though, before we are done for the day here.
All right, Mr. Morris.
Judge, on demonstratives, and when I say demonstratives, I want to make sure that I understand what you're talking about. You understand what I'm talking about. I've got some flow charts or timelines that I'm.
Pierre, it's Rash Baum, but we call him Rashi. He's a finger sniffer. He's a finger sniffer. He's silly. He sniffs his fingers when he's at the defense table. So this one here, his name is Alex Morris. He's the second chair now, the new addition to the team. Rashi defended the whole of Charlie's case by himself. Monster clicks. I don't know. Wait. I don't know, Adam. Good ears. I'll shush. I'll shush.
And constructing, they're not finished or complete yet, and importantly, I don't think they're going to be on Tuesday. I addressed that issue because that's the deadline that we've set. I addressed that issue with Ms. Kappelman yesterday. She indicated that she had similar timelines. We both agreed, with Your Honor's permission, that we're okay not being constrained by the deadline insofar as we share with one another prior to the trial. That way, if there are any issues, we're able to discuss those. In other words, that's a process. So the first thing I ask is for your permission to let us manage ourselves, I guess, to a degree. I think that we're in a good position to do that. What we're discussing as demonstratives are not contentious issues. They're not argumentative issues. I don't believe on the timeline issues. Second issue is because discovery, because of the depositions, there have been a couple of things that have come up. We're working through those in terms of whether there would be additional motions in limine. And when we approach, you'll have a better understanding of it. But that's basically where we're at. Everybody's working, playing fine in the sandbox together, so to speak.
Very well. I would just ask for a status update on September 6th when we have the next hearing as to Sergeant Corbett's testimony and his presentation. It's not that I do not trust you all, but as I've found in the course of my many years on the bench, everyone's saying all is fine until all is not fine.
So it's not sure.
We'll discuss it on September 6th. You may approach.
Donna doesn't look so good, does she? We need a Donna song, Melissa. I don't think there's anything else left here in the proceedings. The judge just left the bench. I love that she's in cuffs. Suck it, Donna. How's that banana bread going now, bitch? Did I say that loud? I did. Judge is beautiful. Judge Everett, he's lovely. He's very warm and fair, and he's got a good sense of humor. He doesn't take himself or the attorneys too seriously. He's so good. I'll send you a few suggestions of lines you could maybe use in a Donna Adelson song. I could use that as my intro for these streams, and your song, which we played at the start. Beer, yes. What Donna's ears, I can't unsee that now. I'll send you some buzzwords, Melissa. I'll think of a few that are tried and true. Absolutely, Darlene. As much as I want to look at Donna's ugly mug, all right. Wait. Hot mic. Not a hot enough mic. Cannot unsee it, Pierre. Here. That's right, isn't it? Not Pierre. Here. All right. Bye, Donna. Ugh. Actually, no, it's lovely watching her misery and her sagging jowls. I love it. Look at her earlobes. Lord. The Donna roast. Here. Yeah, she knows she's screwed. All right. Bye, Donna. Love your work. Not. Evil wench. Hang on, wait. Screen. Ooh. Hi. Let me get rid of that. Okay, so that's the first one from about 2 weeks ago. Let's see what else we got here. This one. Okay. Oh, yikes. In advance, apologies for the facial expression, the dirty pause that Donna starts on in this. Actually, no. Delightful. Is it this one? Yes. Is it? Wait. Yep, no, this one. Okay, so this one was 6 days ago. So the judge has considered some of the pre-trial motions that he needed to rule on, the thumb drive, some things he needed to check on, and clip it. Oh, Donna. Oh, how the lofty have fallen. Feels loud. Wait. Wow.
Of course she did. To do it.
Yikes. Blowing out my eardrums.
I do not know the answer to that, Judge. I'm sorry. Let me concur. I think we should probably assume so.
I see a tile labeled with Markel.
Okay, then yes, Your Honor. Thank you.
Do you have any idea who Misha Janice is?
I do not.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So from here, the Zoom is going to be limited. If I get wind of anyone else trying to do inappropriate things in the midst of the Zoom, ultimately it's just going to be, if you're here, you're here, you're not, you're not. I'll go ahead and allow parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sarah Kaufman Dugan for the state.
Darren Ashcroft on behalf of Mrs. Adelson, who's present. Alice Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today.
Present.
I'll go ahead and allow parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sarah Kaufman Dugan for the state.
Darren Ashcroft on behalf of Mrs. Adelson, who's present. Alice Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today. This is the defendant's motion in limine concerning the testimony of Sergeant Corbett and the summary exhibit. Whoever's arguing the motion may proceed. You may.
Judge, I think we filed pretty detailed papers on this. So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's really important to realize we're not asking that he not be allowed to testify. What we're asking for is two pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the third piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers,
Richard, did she say, oh, Georgia was whispering? Oh, okay. I thought you were saying Donna. I thought you said Donna was whispering. I could imagine it's like, oh, Wendi. The channel that I used to moderate for, Roberta Glass, which is, it's a long story. Anyway, we parted ways. We had a difference of opinion on a couple of things, very strong difference. But gee, she did a good Donna impersonation. Absolutely hilarious. Yeah, Ducati girl. So good. I'll have to see if I can go back and find it and clip it. Anyway, let's get back to it. I'll make it short, y'all.
that he's testifying to anything that meets the standard of Florida statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
I'm sorry, 90 point, correct.
Go ahead.
We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries.
Wait, we're on regular speed.
Law is
Nobody
pretty
needs
clear on
Rashi on normal speed.
as
Lord.
well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
One question before we continue on track of the expert testimony. As it relates to items that the state can properly admit, and I'm sure there, based on including there are aspects of the current PowerPoint that are disputed as being inadmissible, but for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
no, they can be. So in other words,
Oh, I didn't realize we've got the live law and crime chat replay on the side there. Oof. Should I turn that off? I might close that down. I don't know. That's better. We don't need to see that revolting stuff. They're awful, those people. We come to nice, safe communities, right?
there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendi Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendi Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The one thing I would only one other question even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can. Right? They can make arguments just like they do in closing arguments. Right? They can show the exhibit to Corbett, Sergeant Corbett. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329 page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329 page exhibit, it's essentially Ms. Kappelman's closing argument, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room when they're deliberating. But no, of course, they're able to provide its admissible material in it. They're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sergeant Corbett. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about, and it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702 and Daubert, because it involves no scientific, technical, or other specialized skill. Cites King v. State 260 SO 3D 985, Florida 2018. McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sergeant Corbett is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether—
Before you move on after that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, or I guess it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
You've stipulated that. That's one of the things you stipulated too. All right, so we'll have to figure that out. Okay.
Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
Very well. You may continue.
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit, his demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court.
Go ahead.
So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly related matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is prepared this in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury, or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. That is not admissible under law, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence. Care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. one-page text messages, not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. Again, we're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now. Within the exhibit, we
as to any pages that are specifically disputed as inadmissible, it's best to have.
I remember when this was wild to me when oh hi Scott, thank you for coming. Good to see you. You're up late. When Roberta Glass was talking about the Charlie trial, Charlie Adelson, and she didn't know what a demonstrative was. I'm like, I mean, just by definition, it's not evidence. It's something to demonstrate. Demonstrative to the court, to the jury, to the fact finders, what is being shown in court. Pretty simple, right? Anyway, back to it. How was your standout today, Scott? You're such a trooper.
Outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience.
Exactly, here.
The state has still been updating it, so things may change. But we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic. And we can take that up whenever you want. But our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday if there are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well, State, you may respond.
Right, Mariah? But at least it's better than bloody Lally. Lord.
Good morning, Judge.
Good morning.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence. And they cited
Looked amazing,
the King
Scott.
and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbett. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses the more.
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information, but they're not saying that you cannot present an expert to offer an opinion on a handset's location. If that witness has the necessary training and experience, just
Thanks, Adam. You're the best. I said her hair is gorgeous. Isn't she just so beautifully and coiffed and so elegant? And but she and Georgia are so very Florida. I feel like they are with their blonde foils and their Florida look. And Buster, my dog's name is Buster, which I got him when I was actually no. I was listening to True Sunlight, the the Murdoch family murders podcast with Mandy Matney, and got Bussy and called him Buster, and then was like, ooh, excuse me, am I really wanting to do that? But I did. Anyway, muted. Thanks, Adam. You're the best.
Just as was done at the hearing in the King case and could have been done at the trial of the Gordon case. And Sergeant Corbett has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are in any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbett, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with the cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case,
I'm sorry, I know we probably shouldn't comment on people's looks because that's not really cool, but I mean, I just love how she's even got her sleeves pushed up. Sarah Dugan is a very good attorney. She could absolutely prosecute this case if Georgia wasn't the lead state prosecutor. She's so elegant and beautiful. They're all class. Oh, Georgia, I froth over Georgia. Check out hey Adam, can you please drop the can you please drop the link to the playlist in the chat so that people can know it's there? My Adelson playlist, Justice for Dan Markel.
Evidence that it is very all-encompassing. However, there's not what's in the presentation is not. It's all data. It's messages. It's emails. It's different business records and cell phone records.
Scott, in the description of this, this live and the previous live, there's a very brief couple of paragraphs about, excuse me, what's happening here. I've also got a whole playlist which Adam just dropped into the chat now, which is 86 or 87 shorts that I did on the previous trial for Charlie Adelson, who is Donna Adelson's son. They're both, Charlie's now in jail for life without parole for the murder of Florida state law professor Dan Markel back in Tallahassee in 2014, who was the ex-husband of the Adelson, of Wendi Adelson. And so they hired two hitmen to get rid of the ex-husband because of a bitter and contentious divorce and child custody battle. So it's going to be a doozy, this trial. It's a shit show. It's an absolute shit show. But she's going to get convicted for sure. No. Charlie was convicted in under 3 hours, just over 3 hours, including lunch.
Phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I'm may use in my presentation. I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbett sit up there and read all of those, but I wanted to send them all of the ones that I may use as far as just, these are what was found in these different accounts. This was some, and asking him, hey, did law enforcement
Also in my, oh, wait, am I
find
muted?
some evidence of motive
No.
that caused him to look into these
Oops.
people?
Wait,
Yes,
wait, sorry.
X, Y, and Z
I'm a
were
professional.
found.
In the in those shorts, the ones that feature Wendi Adelson, there's a few paragraphs, a full context on her sort of part in the murder, allegedly. She's an unindicted co-conspirator at this point. And in the shorts that feature Charlie, there's another one that's more about him. So if you watch any of the shorts in that playlist, you'll see those sort of further elaborations, give you a bit more context, because I was getting a lot of, what the hell is this? What's the point of this short? So I started to put the same comment in a few paragraphs so that people would stop busting my balls about it. It worked.
Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, I believe the defense's motion hits on this as well. For what you have asked Sergeant Corbett to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbett's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbett's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbett doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbett and say, hey, is there any evidence of X happening? And he lets me know that. That may corroborate what the witness says. And then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on what the data shows, where that handset was at the time, how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own.
Scott, that's rough.
The defense
Yikes.
motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them. And there's no case law that I know of that says otherwise, that a summary isn't admissible. It has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that. And the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least in putting their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone record, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helped him form his opinion.
Very well, thank you.
Thank you, Sarah. Beautiful girl.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this is in the proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too, because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
All right, concerning this motion, I'm prepared to rule on part of it today as to whether or not Sergeant
JC, excuse me, JC, I think she's just put on a couple of pounds because of the bologna sandwiches in jail. We all know Donna didn't care about kosher food, but I think maybe jail food is taking its toll. I don't think anyone would want to shoot Donna. I think they just mostly want to see her rot in jail, right? I know I do. Suck it, Donna. Suck it, evil wench.
Corbett can be properly qualified as an expert witness. I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that will go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part two then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine.
Oh, girls, wait.
As to
hot bailiff alert, girls. Ooh, I hope he's going to be in court every day. Yes, please. Sorry, Adam.
the storyline of her book and also changing the names of the children. I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to your honor. May I clarify what you just said about the name changes? You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that. Well,
Adam, your beard is luscious.
I'm sorry. I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Tugin can't ask her the question, did you change the kids' names? That was what our motion was. So I'm not sure I'm just not sure the ruling. Can you ask that question?
Well, on that particular point, what it was
Hey, Pat.
for Ms. Kappelman.
This is your deal, Pat. We're here for you.
For that reason, or also impeachment, depending on what comes out. Motive and bias.
So massive callback, deepest of deep cuts. Pat Sanford is the FBI agent who came out of retirement, not this Pat Sanford, although I did ever hopeful in the Roberta Glass chats that you were the real Pat Sanford, and I did think that you were a guy until like 3 weeks ago. But Pat Sanford is the absolute OG goat who walked up to Donna in the jetway as he was about to arrest her and said, "You recognize me?" And she, of course she didn't, because Donna's just Donna. What a hell, man. Cannot wait Oh, Pat Sanford. Stan. Hot bailiff.
Equally available for both parties to explore. As to the state's motion in limine, I believe there's also one other outstanding item to be addressed concerning Luis Rivera's gang affiliation. As to this particular point, and I've researched this further, Mr. Rashbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies, that she acted in accordance with being threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. I believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Bingo, Darlene, bingo. It's all right to look at a player,
Judge,
just not to play with the player.
Contemplation, like a planning, when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday?
Assuming that we have the jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning those?
You have 1 moment.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go to their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rushbaum? Very well. If we have enough time then, after we have the jury selected and sworn, we will give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say, it depends, obviously, but I would think 2 days.
Very well. Nothing's going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you in a previous hearing,
Yikes, this law and crime cameraman is on something. The Blair Witch of it all, says quote Emily D. Baker. Yeesh. Steady your hand, sir or ma'am.
I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denier is sworn, that means trial has started. From there, basically because of count 1, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, sir.
Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th. Yes, sir.
Maybe briefly go sidebar.
Yes.
Rashi, a bloody sidebar. Sort your shit out, mate. What? A sidebar? There's no jury. Oh, Georgia, you fox. Oh, I'm not gay, but Georgia. Yo. Oh, player.
That is the conclusion of the hearing for today. Have a good Friday.
100%.
Recess.
She is a fox. Queen Georgia. Wait, okay. Bye-bye. Thank you, Lauren Crime. So that's that. Yeah, George is a fox. And I think because she's just her sass, her snark, her calm, like she's just prosecution perfection all day, every day. Yeah, for Georgia, mate, I would, in a heartbeat, I would turn for Georgia. She's on my clout chasing hit list, to be honest. I'm going to see what I can do there. Might have to wait till after Wendi is convicted, which will happen. All right, we've got one more. She's so, yeah, Wendi is next. TikTok Wendi. Countdown. Look. I just made a short before of Donna acknowledging that she had no plea being offered to her, nor were they providing one. 2 hours ago, it's already had 761 views. Yay. All right, let's go to the last one that I've got going. It's subtle compared to AJ, but perfect. Yes. Her calm demeanor, she's unflappable, right? Oh, she's just the queen, Queen Georgia. I said it in last night's stream. If you missed, we did go over the second most recent, or one from about 12 days ago, one of the pre-trial motions. And I did mention there is a Georgia Cappleman Appreciation Society Facebook group, which is fantastic. Not someone I'm affiliated with who runs that group any longer, but it is a good page. I still belong to it, so begrudgingly. Oh, whoa! Wait! Something just went in my ear. You can't hear it. I can hear it. Hang on. Hang on. Yikes! I'm getting deafened. I'm being deafened. This one. Yikes!
His attorney-client protected conversations with his client. There are three categories that the state seeks, the defense seeks Mr. Marcus's testimony.
Okay.
The state has indicated, and they reaffirmed to Your Honor that they intend to ask Investigator Isom.
So wait.
Called immediately after.
This is the start of this particular stream, and I might be putting things out of order, but anyway. So this is the more things. It's a different bailiff. Yeah, damn it. So it's more things that the judge has ruled on, is about to rule on some things. So yeah. Oh, I love this Georgia appreciation. I'll make a Georgia emoji and emote and a Donna one to put in for members. I haven't done it yet because I've been a little bit Billy. I've been a little bit busy. All right, let's keep going. Thanks for being here, y'all. It's so exciting to see all my faces and my friends. And yeah.
Manuel was arrested. The jury, if left there, the jury takes away that someone or somehow the defendants are all in cahoots, if you will. The defense believes that Mr. Marcus would testify that is not the case at all, and he would provide information as to how it was that he received information.
Maybe Ducati girl, but here are all of us ready to turn on a heartbeat for Georgia. So there's hope.
And about Ms. McManus' arrest and how he knew to call Investigator Isom. That's the first category. The second one is the state has investigated vigorously to try to pinpoint that the Adelson family has provided legal fees for other lawyers or other co-defendants in the case. I don't know whether the state seeks to elicit testimony of that nature, but as recent as January of this year, the FBI was down in Miami speaking with Mr. Marcus about such things. Mr. Marcus provides an explanation that doesn't involve attorney-client privilege that didn't happen. Mr. Marcus made a suggestion of the potential legal strategies involved, but nothing ever came to fruition, and there were no discussions with any co-defendants or the Adelsons. And then the third category, Judge, is there's a text message between Mr. Marcus and his client, Charlie Adelson, at the time about him having seen or bumped into Katie McManua outside of his office, and there's a comment about something to the extent of it being a coincidence, but
No, so we don't have anything televised, Pierre. So that's why I think there's a pretty huge fascination of Aussies to the American legal justice system, not necessarily a justice system at all times, right? Because so that you can access documents, we can access documents, but there's no televised anything. So it's kind of, it's not really as voyeuristic as it is with you guys. I mean, Florida, you can't beat the sunshine laws, right?
but there was no conversation that was had. Again, if the state elicits that testimony in all three of those categories and it's left hanging, it goes unanswered. But in each circumstance, Mr. Marcus is able to respond, and I don't believe that it invades the attorney-client privilege.
Mr. Marcus, I'll allow you to respond to what the defense is proffering and why they would seek your testimony.
That's
Thank
South
you,
Africa,
Robert.
Ernie.
And
Yep.
So I'll take the easiest one first, which is the last one. I had not heard about this text message between me and my former client, but that would obviously be privileged. And so any testimony regarding a text message between me and Charlie Adelson, I would not be able to comment on. So that I think is the easiest one. Let me take the other two.
Let me ask you one question before you continue. Mr. Adelson has not waived any privilege with regard to you.
Correct.
You may continue.
Thank you. Yes, I have not been informed that he's waived any privilege by him or anyone else. The other two categories, and I'm sorry for not looking always at the camera, looking at my notes here, Your Honor, but the first is the call to Detective Isom. So I guess I just don't understand how the state putting in this evidence is relevant, and therefore the underlying evidence in my response to it, I think, should be suppressed. The idea that on the morning that Katie McManua was arrested, I learned of that arrest and called the detective to find out if Charlie Adelson was being arrested. There's nothing wrong with that. That's what any good lawyer would do. The defense is right that I would respond to any nefarious suggestion by the state that there's nothing wrong with me calling the detective to find out if Charlie was being arrested that morning. But I guess my response would be, I don't think that initial evidence should be able to come in that I made a phone call to the detective to inquire about Charlie. Certainly that has nothing to do with Donna Adelson. And even if this was a trial about Charlie Adelson, I don't think it would be relevant, Your Honor. I was trying to find out whether the detective that morning was going to arrest Charlie. And nothing wrong, nothing untoward or abnormal about me calling the detective to inquire about that. So I would ask that whole little snippet be excluded, the underlying evidence, and what my response would be to it. The final thing about legal fees, I addressed this in my motion. I've spoken to the state about it, so I don't think they're going to elicit anything about this. They released me from my subpoena on this issue, so I'm not sure that the defense needs me to rebut anything, because my understanding from speaking to the state is they don't intend to elicit anything on that issue.
Ms. Kappelman, Ms. Dugan, are you seeking to elicit any information or evidence during the trial that would concern Mr. Marcus?
Potentially, yes, Your Honor. We are seeking to introduce the evidence that I mentioned previously at our last hearing about the call to Isom.
Yes and no, Shiraz, because we have very strict gun laws here and in the UK. So there's a lot less hectic shit. There's a lot of domestic violence. We're the same, and the epidemic is the same here in Australia as it is everywhere else in the Western, and probably not only the Western world, with an average of one woman per week murdered by her partner or ex-partner or significant other. So it's really quite it'd just be all drug stuff, drug crimes, a lot of bikie and gang related stuff, but we don't have as many limited access to guns. Very strict gun control means that there's not as much happening. I say this like I'm just making it up. No, that's true about the gun laws. I don't know about whether they're crimes is, I don't know. I don't know the statistics. I probably should know. All I know is about you guys, you wild, crazy Americans.
And the relevance hook of this would be it goes your conspiracy theory or what exactly?
Yes, sir, exactly.
And in Australia, barristers wear
Would
wigs
I
here
get
too.
into anything about the offer from Mr. Marcus to Catherine McBanaw's attorneys to pay her attorney's fees on behalf of the Adelsons? Potentially, yes. And what's the third question?
I believe the last
Oh,
matter
well,
was
I was-
any text message between Mr. Marcus and Charles Adelson when he was representing him.
Yeah, I think that the defense has mischaracterized that evidence, but that is a piece that could potentially be inquired about as well.
All right. As to the first issue of the phone call and whether it goes in any form or fashion to the conspiracy, what I'm going to rule is the following. The state may inquire as to the topic. If the defense has a factual related line of questioning to ask Mr. Marcus, the factual line of questioning will be permitted. Nothing that goes into attorney-client privilege may be inquired to. Is everyone clear on this?
Yes.
Very well. As to the second line of questioning, again, Ms. Kappelman, this is being offered for what exactly concerning any possible agreement or payment?
Yes, same relevance argument here that it goes to conspiracy, the existence of the conspiracy.
Right. As to this, were the defendants, well, I believe the privilege argument gets a little more thorny at this point. What exactly can Mr. Marcus offer that would not be privileged on this issue?
Are you inquiring to me, Judge?
Either party.
I just realized we're on normal speed. Lord,
My understanding, and Mr.
what am I doing
Marcus
to
can
us? Sorry, y'all.
correct me where I'm wrong, is that there was a conversation with Katie McManaw's counsel. I don't believe that Mr. Marcus conferred with his client, but it's something that he does in his normal practices, which a lot of lawyers do, myself included, call co-defendant's counsel. If there's a necessity of sharing expenses, I think it was his suggestion, and just that, his suggestion versus the Adelsons.
Mr. Marcus, is there any argument as to why this is privileged specifically?
No, Your Honor, if I'm asked the privilege question on the stand, of course, I'll just invoke it at that point. I have no problem doing that, Your Honor. Your Honor, if I could just be heard for 1 second.
Go ahead.
There is, of course, a difference with the state arguing the existence of a conspiracy and crazy conspiracy theories. There is no basis to argue the existence of a conspiracy by my calling the detective to find out whether Charlie Adelson was being arrested that morning. There's just no, they have to at least allege some tie, some basis in fact.
So good, Ernie. So good.
Conspiracy
So
that would have
good.
some relevance in this trial. I was calling to find out from the detective whether he was arresting my client that morning. There's nothing tied to any conspiracy, certainly with Donna Adelson. So it's just a conspiracy theory with no basis in fact, Your Honor.
I fully understand where you're coming from in both your pleading and your position.
Okay, so this isn't Rashi. This is Charlie's previous. Oh God, Charlie's previous attorney. I didn't catch his name. But they basically he called on the day of Charlie's arrest the detectives to see if Charlie was going to be arrested. Anyway, so they're trying to say that that was consciousness of guilt and part of the conspiracy that basically and whether it's privileged, attorney-client privilege, so this isn't Rashi saying my client. This is some other dude, previous attorney, not nearly as much of a hard hitter as Rashi. Finger sniffer.
Position this morning as a factual issue. Did the phone call take place? There is nothing protected concerning that. How that fits into the larger narrative of what may be admissible or not, yet to be determined. The state, they have their fair opportunity to put on their case. If further objection needs to be raised at that time, I will address at the time. But as to the pure factual issue and whether or not you have knowledge on that topic, that does not go to privilege. That is where they will be permitted to inquire. That is where the defense will be permitted to rebut. Nothing more, nothing further. As to the second issue of the offering of fees, is there any privilege that you can assert concerning this, or this was just an idea between you to the other attorneys?
The latter.
As to that topic, factually, it may be inquired into. How this again fits into the larger weaving of the evidence. If there needs to be an objection at that time, it may be raised, but on the pure factual issue, state may inquire, defense may rebut. That's
Hey,
the third
Ken.
issue of the text
Thanks for
message between
coming.
attorney and Mr. Marcus and Mr. Adelson.
I have my facts wrong on that, Judge. I'm sorry for interrupting. The message is actually, Mr. Marcus spoke with Mr. Adelson. Mr. Adelson then communicated with his mother that he had spoken with Mr.
I think what they're trying to say, what the state is trying to say, is that it's evidence of the conspiracy, that there was collusion going on, and so they all need to know because they were all in on the conspiracy. That's not the consciousness of guilt, but the collusion in the conspiracy.
Mr. Marcus, and Mr. Marcus had indicated that he had bumped into Ms. McManus. So my sequence of events a little off.
And the state would be seeking to offer this also under the same conspiracy theory.
Yes, Your Honor.
Ken!
Right? Mr. Marcus, are you alleging or asserting at this point that a privileged matter was discussed through that text message?
I don't know what text message they're referring to, Your Honor. I have not seen it, but if they're referring at all to a text message between me and my client, of course, that would be privileged. If I'm hearing Mr. Morris right, he's now referring to a text message between Charlie Adelson and Donna Adelson. I don't know whether that would be privileged or not. I doubt it, but I don't have any. That's not between me and my client and my former client.
Was this a communication that was captured through the wiretap?
No, sir. It's part of what was captured off of the devices that were searched.
So this was a text message from Mr. Adelson to Mrs. Adelson?
That's correct, Your Honor.
All right. As to that, Mr. Marcus, if it does not include any advice or opinions that you're providing to your client, if there was no joint defense agreement concerning them, ultimately this can be argued as a communication between co-conspirators. It just merely mentions your name, if I'm understanding this correctly. Is there any correction that needs to be given on this point? Okay.
No, Your Honor.
Very well. As to that, the state may inquire as to the communication, as to anything that Mr. Marcus discussed with Mr. Adelson that may not be inquired into, but the substance of the text message. If the state in some way is going to argue this goes to conspiracy, they'll be given an opportunity to do so. If an objection needs to be raised, you may do so contemporaneously during the trial itself. So Mr. Marcus has a better opportunity to plan. The parties know when he would actually need to testify. I'm sure he has a very busy schedule, and we're not trying to create a hardship or inconvenience as it relates to his work and business.
As soon as the state rests, the defense intends on calling him.
When I believe your previous estimate, Ms. Kappelman, was 6 or 7 days.
Yes, sir.
Let's pinpoint on the calendar then, at least a projection that will assist the witness determining when he would need to be present. Jury selection begins next week on the 17th. And if we have a jury by Thursday the 19th, the first day of trial, would be Friday the 20th. And that means by Friday the 27th, potentially the state is resting its case, which would lead us then to Monday the 30th, the beginning of the defense case, unless I'm off of my calculations.
You're correct, Your Honor.
You're correct. And the defense has a bit of a time pressure also because of the Jewish holidays.
Mr. Marcus, if you can go ahead then and mark on your calendar as to when you may potentially be called, starting with September 30th. If there is any hardship that you need to address in other cases or matters that you're involved with, please let the parties know. If I have another state court matter, perhaps I can pick up the phone, free you up.
Thank you, Your Honor. I do a federal court on the 1st, but I'll work with the parties to see if I can get called on
Hey, wait.
the 30th if it's actually going to happen. I suspect, Your Honor, that when the factual issues come up in trial, that there will be some debate about whether these items should come in because, again, I'm not.
Wait. I've just noticed Rashi's got beard there. Do you think that he got feedback that his baby face was actually a fat face and he maybe needed to grow the beard back in a week? Do you reckon that's a week's worth of growth? Could be. I think this is from 2 days ago. Let me check. I should have checked. They're definitely arguing. Wait. See how professional I am? I'm pretty sure, I don't know, can we check with Jonna's regrowth? This is definitely, anyway. Rashi's got a beard in this one. Good choice, Rashi. That double chin. I think grow the beard longer though, right? Hey, no barking.
The 3 topics don't go to any
Jesus.
actual.
Hey, stop that.
I'm hoping that when the objections are raised,
No barking.
I'll be if I need to come on 30.
All right. That concludes the motion to quash the subpoena. Have a good day, sir.
Thank you, Your Honor.
All right, let's continue next with the continuation of the motion on the summary. Is Sergeant Corbett present?
Should be judging me.
Oh, and also, so the record is clear on this matter, the motion to quash the trial subpoena is denied as to all factual issues in which Mr. Marcus would have personal knowledge and can testify relevantly.
A bit, a lot. Poor guy.
On the elevator or something like that.
Hi, puppy.
We do have we do have another part of the motion, if you want me to
Puppy.
take up in the meantime. which
Sure.
is They had objections to specific parts of the presentation as to hearsay and attorney-client joint. privilege.
Shiraz, we've been lampooning him hard here, so yes.
May I approach, Your Honor?
You may.
Judge, it's changing the document, so it's based on what I have so far. So there may be more that comes up in trial. But based on what I have right now.
You've reviewed it all, correct?
What's that?
You've reviewed all of it.
I've reviewed all that we have as of now.
Right, go ahead.
So page,
Ernie, his last name is Rashbaum. So we just, as a sign of respect, we call him Rashi. He likes it. He likes it, so I've heard. He also likes being lampooned for his fatty
I
face.
think it's page 20. It's an email between Donna Adelson and Renee Griggs. And below it, it's in response to an email from Renee Griggs to Donna Adelson. It's hearsay.
What is this being offered for?
Judge, in that email, the defendant explains that she is stressed about her daughter not being able to relocate. You know, that her daughter, I think, doesn't realize how much it will affect her life, Donna Adelson's life, their whole family's life if this doesn't happen. The comments from the counselor that are concerned about her stress
Tiff
level, I think
Knox.
just add context.
Back.
That's what we would be asking for the whole email to be admissible for. And it's
So
also-
you're not offering it for the truth of the matter asserted, or you're offering it as a party opponent admission of
We're
some
offering,
sort?
yes, we're offering Donna Adelson's comments as admission by a party opponent, also a statement against interest about how stressed she is about her daughter not being able to relocate and how much it will affect her family if it doesn't happen. The therapist, or the not therapist, life coaches.
Even if we didn't know that he is extremely short, and Charlie Adelson is 6'1" or 6'2", so it was quite laughable, but Rashi definitely gives off short man vibes, right? He's doing everything in his power to overcompensate for his tiny man stature. I mean, the world needs all heights of humans, but Rashi very much fits the bill with his personality.
Comments that are also contained in the email would only be there for context.
Very well, as to that point, Mr. Rauschenbaum, I will permit slide 20 if there is any limiting instruction that you wish to give concerning Mrs. Griggs' responses as only providing context to what the
Yes,
admission may
Tiff,
be. That would be
PJs.
appropriate, but if these are party opponent admissions, they are permitted.
Judge, may I briefly just respond to be heard?
Go ahead.
The problem
100%.
isn't Donna Adelson's comments. We don't have a problem with that. Those are statements against interest. And they're not confusing at all. They say exactly what they just said. The problem is Renee Griggs' email to Donna Adelson, which is hearsay. It doesn't give any additional context to what she says. You can understand Donna Adelson's admissions by her email alone.
So you're saying part then of this is just a response from Griggs to your client?
No, it's a chain, right? So it's a chain of emails between the two of them. We have no issues with Donna's part of the chain coming in. The problem is Renee Griggs' chain doesn't, it's not confusing what Donna's saying. I can read it to you. She says exactly what they just said. So if you never heard what Griggs says, she says, I'm stressed about my son, but honestly, I'm more stressed about Wendi and what will happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Hope your mother's doing better, or at least stable, Donna. So if you just allow that in, which we don't have an objection to, that's a statement that Donna Adelson's making, you're okay. But
Does Griggs respond from there? Does your client respond from the response?
No, Griggs doesn't respond from there, but Griggs' email below is, hi, Donna, I'm not sure, and I only have part of it, but I'm not sure if you're back from your trip yet or not. I planned to check in yesterday. However, my mom was in the hospital and I was handling family stuff, so I was a bit out of pocket. More than anything else, I want to see how you're doing. It seems as though you have a great deal of weight on your shoulders. I could both hear and feel it on our phone conversation the other day. I'd really like to be able to help you shed whatever it is that feels so heavy. Please know I'm thinking of.
Buzz cut? Donna could go a buzz cut? I don't know. What could we do with that hair? I don't think the hair's really the problem. I feel like she probably should have had a bit of foresight and planning and gotten herself a facelift before she got arrested, before she went to Vietnam. Maybe she was going to Vietnam to get some surgery. Also, hey, Mona, it's good to see you. Thanks for stopping by. The dogs are going cray-cray. Guys, yeah, puppy.
Thinking of you and looking forward to our work together whenever you're ready. Take good care of Renee. I don't see how that isn't blatant hearsay without any exception. It doesn't, you understand what I mean, again, the relevance that they just put it in for is exactly what Donna Adelson's email says.
Tiff, put a bag on it.
What exactly context is being provided by Mrs. Griggs? first email before Ms. Adelson responds.
So the defense, I think, accidentally, when they read about, yes, I'm stressed about my son and my daughter, she doesn't get relocation and how all our lives will change drastically. That was Donna Adelson's email. The last email he read was from Ms. Griggs. In that email from Ms. Griggs, who's the life coach, she basically is just saying, I'm checking in on you. You seem last time to have a great deal of weight on your shoulders. I'd like to help you. And that's when Donna Adelson talks about how stressed she is and how much their lives will change drastically. So I think that the life coach's email just gives Ms. Adelson's comments a little bit of context as far as explaining why.
I'm so sorry, but lol, Donna had a life coach. Did we know this before? No. Is it hilarious? Absolutely. I don't know how well qualified or effective that life coach was, because make better choices, Donna. Ay, 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 ay. Yeah, she's looking hard. She's looking beaten, but I think she still looks defiant, somewhat.
She's kind of pouring her heart out there and explaining why she's been so upset.
How much further does this chain go beyond?
I'm not seeking anything more than this page. I think there is more of this chain, but this is the only page I'd be asking for.
I'll reserve ruling on this from now. I'll look at it again when I have my thumb drive and can review the slide in its entirety. Go ahead.
Judge, I think the next item we have, I think we've gotten new slides on this, but I'll go, I think for ease, we'll go on the slides that you have, because it's the same issue. If you go, it's slides 255. We don't actually have new slides on this, I apologize. It's slide 255, where Agent Corbett is estimating how long travel takes. We're moving to exclude that based on speculation.
Okay, so I have been arrested and been entered into a custody situation. It was only for 12 hours, but one does need to squat, if only momentarily, and bend over to prove you have nothing secreted in one's orifices. So she would have had to squat, if only once. Or actually, every time she gets transferred, they'll be checking out all the gaps and holes to make sure there's nothing in there. Too much information? No, it's just how it is when you get arrested and put into custody.
Stugan, did Sergeant Corbett do any calculation or in some other way develop this information that can be demonstrated as reliable?
Yes, sir. So on this slide, we have actual versus optimal travel of Wendi Adelson on the day of the crime. The actual travel is based on the events in her call detail records, where it shows the cell towers that her phone is communicating with as she leaves her house and goes on her way that day from by the crime scene to ABC liquor store and up to lunch. That's based on call detail records. And also other evidence like an ABC receipt that she had that day. For the red dotted line, that's the summary of the shortest route. So we're saying this is the actual route versus the shortest route she could have taken from point A to point B, her home to where another liquor store is in the restaurant. What he uses to show travel time or miles is a company called, or a mapping company called Esri, which is, and if you need to hear more about it from Sergeant Corbett, he'll be here in just a second. But basically that is a software that Florida Department of Transportation uses for their mapping and mileage calculations. He uses this very regularly in all of his mapping and travel calculations and all of his presentations. And he knows it's reliable because several times he's tested it himself. He looks at where the map says the travel time should be in the miles, and he does the drive himself. So he's been able to personally test this several times, and it's been accurate. And what we have in this slide is, one is call records, the other is the summary of the shortest route, and it's literally just saying, hey, this is point A, this is point B, and this is the mileage according to Esri, and this is the minutes it should take, and it's twice as long as the actual, or twice as short as the actual route.
All right. The sergeant also will be able to testify as to his knowledge of this program, its use, and the fact that he is qualified to use this program.
Yes, sir, and I can ask him those questions today if you'd like me to, but he regularly uses this program and has knowledge of it, is qualified to talk about it, and has had personal knowledge of testing its accuracy before.
All right. On this issue, Mr. Rauschbaum, you're essentially objecting that either the sergeant does not have an accurate calculation or in some way misuses the program. What exactly are you getting at?
May I have one moment, Your Honor?
Go ahead.
Judge, the objection isn't as to his knowledge, and you know what, we'll withdraw the objections.
Very well.
Rather
Let's move on.
Judge, the next one, and let me just confer with my co-counsel for 1 second.
Go ahead.
Judge, the next one is page 318. some messages between Charlie.
I feel like I've heard somewhere that it's $60 or something on the commissary. And didn't Alex Murdoch start to Alec start to like con other people? Something. I should think before I start speaking. I think it's about $60. I may be wrong. I mean, how many beef jerky sticks can you buy with that? That could be something to research. Someone? Anyone? It's not going to be me.
Charlie Adelson and Donna Adelson. Charlie Adelson's messages are hearsay, and they're not in furtherance of a conspiracy.
Response, Stu?
Yes, sir.
I could just give you the date of the messages too.
Go
The
ahead.
date is August 2nd, 2016, which is after the arrest of Sigfredo Garcia and Luis Rivera.
Stu?
In the motion, defense also objected to this on the basis of joint defense privilege. Is that no longer being argued?
It's not that. The document we objected to on behalf of joint defense privilege is hold on, let me just double check. Is a different one, and we're going to withdraw that objection, and given the court's ruling earlier today.
Okay.
This doesn't have to do with that because it doesn't mention.
This
Mr.
is just
Marcus.
hearsay, okay.
It's just hearsay.
All right, so Judge, on page 318, what we have are co-conspirator statements. This text message is, it says, this is from August of 2016, so this is going to be after the arrest of Garcia and Rivera. It says, from Charlie Adelson to Donna Adelson. Did you see in the paper where the state star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time.
Thank
Maybe
you.
The coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. This whole thing is just crazy. Then Donna Adelson goes on to say, I didn't see which paper. Charlie Adelson says, Tallahassee Democrat. Miss Adelson says, wow, I stopped reading everything. Charlie Adelson says, the guy admitted to selling them cocaine and hanging out with them. And Donna Adelson says, OMG, exclamation point. Our argument would be that this is co-conspirator statements. This is nothing more than co-conspirators celebrating another possible explanation that does not involve them for this crime. They are theorizing about another possible explanation for Dan Markel's murder. And this is showing just their theorizing and celebration of something that doesn't involve them that could explain the murder.
In response.
I don't understand it. I mean, it is. I mean, I can show you the text messages in its entirety if you would like me to bring it up, but that's not what's happening there. And I don't even.
I'll review it with my thumb drive as well when I go through slide deck. The problem with Dugan that I'm drawing with this, the communications do not have to be so overt as to saying, we're hiding the gun here or something of that nature. But them essentially mocking, I guess, the drug dealer or the fact that someone else has been arrested in furtherance of their conspiracy. I guess flesh that one out for me a little bit more.
Well, also, I mean, their defense is that they were extorted, and this message pushes back on that. At the time this text was sent,
Don't speak over each other.
Garcia and Rivera had been arrested already. So Donna and Charlie Adelson would have known the people behind Dan Markel's murder. And now those people are behind bars. And now, so why, if they've been extorted by these people for the past several years, why are they theorizing about another possible explanation for the murder? They know what happened to him. Those people have been extorting them for years, and they're arrested. Why are they now trying to say, maybe he was killed by a cocaine dealer for stiffing him? Why are they theorizing and celebrating something that doesn't involve them?
All right. So in all logic, you're not offering us the truth of the matter asserted, but rather to rebut any theory defense is planning to present about a extortion conspiracy of some sort.
Right. Yeah. I'm not offering it to show that the state star witness was a cocaine dealer. Maybe Dan Markel was killed by a cocaine dealer, or that's what Charlie Adelson actually thought. It's to push back on extortion.
As to the basis of which it's being offered, Mr. Rashbaum, what is your argument?
The key is you got to look, and I'm happy to.
Thank you so much, Shiraz, for the copies. You're amazing. Thank you so much. I was able to buy a MacBook a week or so ago, and so it's perfect timing because now I can. It was a reconditioned one, secondhand. Cost me $1,000. Big bickies for this poverty-stricken YouTuber over here. Thank you so much, Shiraz. I really appreciate that. It's really kind of you. And I love that you love my vibe. I love your vibe. I love this chat's vibe. You guys are amazing. So thank you for being here. I really appreciate it. It's pretty cool, actually. This is the trial. I've been waiting for this one. Yeah, we've been waiting for this one. Bring it on.
You have to look at what Donna Adelson says. She doesn't say any of that. She's asking what paper, and I don't know what you're talking about. So it's Charlie Adelson's statements after the conspiracy, the alleged conspiracy. after the arrest, after the murder, and Donna Adelson doesn't respond in any way to what he's saying. She doesn't have a clue what he's talking about.
As to this slide, I'm going to reserve for now. I cannot ask you to show your defense or what you plan to argue. But ultimately, if any way, if it comes down to your client was relying on statements of Charlie Adelson in some way concerning her behaviors and how she conducted herself and whether she in fact knew of the extortion. If the state plans to rebut the extortion theory of defense, it is permissible as to that basis, but not for the truth of the matter asserted. If a limiting instruction needs to be given, it will be given as to that specific slide. You may continue.
The next one, Your Honor, I don't have a page number. Let me see if I can figure it out. I think it's 321. It's very small writing, and it involves text messages between Donna Adelson and Wendi Adelson after Charlie Adelson's conviction. Again, the text messages by Donna Adelson are fair game, but the text messages by Wendi Adelson are hearsay.
Oh, everything Wendi says is hearsay. Let's be honest. If Wendy's talking, she's lying. She's evil. She's next. I love this idea. I don't know if I'm the right person to find this, but if anybody's out there as a research person, we need to find out Donna's her commissary purchases. I guess that's a FOIA request, right? Right? Do you get commissary in jail, or is that just prison? I don't even know. Yeah, Coke deal gone wrong, Pat Sanford. Yeah, we could make like bologna mignon. Bologna mignon. Aye. That's pretty cool. We'll do some fun stuff. This is exciting. I'm here for it.
The timing of it is critical. It's after the verdict. It's actually the hours after the verdict in Charlie Adelson's case. So I'm not sure how it could be in furtherance of a conspiracy.
So I think that I may be able to
Love you, Annie.
on this. I think that I'm going to, there's several messages between Wendi Adelson and Donna Adelson in this chain. I would only be using from when Donna Adelson says, prayer hands, you shouldn't have to pray. He's telling the truth. He protected his little sister from years, to your brother protected.
Ken, I am Australian. I'm Canadian originally, born to Canadian parents, adopted by Aussie expats, lived in Boston from about the age of 6 months after my parents relocated from Hamilton to Boston. We lived in Needham, and then when I was about 3.5, we moved. They returned to Australia, and I have stayed here ever since. However, I am planning to move back over to the US ASAP.
Protected you for years, now you're not guilty. I wouldn't be offering anything after that. So I think the only thing Wendi Adelson says in the meantime is, I love you, call me if you can.
If that's all, then we're okay with that.
How about that? Let's move on.
Okay. The next one is page 324. So
We can come to an agreement on this one too.
we're on a roll.
Shut up.
So you're not-
Douche.
Do we need me any further? Call it a day.
I'm not going to use that one in the presentation.
Okay.
I tried to give them all the things that I could possibly use and have tried to whittle it down some.
Just to be clear, that's the Cellbrite with the website pages.
I will be using the website page for the non-extradition countries, but not the emotion.
Okay, we're good. That's all I have for now, Your Honor.
Very well.
On this issue.
As to slide 20, I will review the entire email chain and then make a ruling on it. Is Sergeant Corbett here?
Yes, he is.
Go ahead and step down.
Actually, on that note, the last time I was in the US, I was competing in Natural Olympia in a bodybuilding competition in San Francisco in 2009, November. And I was there for Obama's inauguration. So, no, wait. No, that's in January. He must have been when he was elected. So there you go. Trust me, the wheels of Lisa do not turn quickly. I have got all my peasant work shit and my YouTubey shit to do. So I will do it as quickly as I can, but it is the plan. Absolutely. It's gonna be Adam Drive Shorty in Helen. I'll post some pics in my community tab of me when I was a staunch bitch.
Sergeant, please raise your right hand. Do you swear
Adam's
or
on the
affirm
West
testimony you
Coast.
will give today will be the truth?
We're going to be in
Thank
Oregon,
you, sir.
but mobile.
Dugan, I will allow you to inquire. The only thing that I would ask is that you hit the points that essentially were at issue in the last hearing. If there's other examination you have for the sergeant, you certainly may get into that as well.
Okay.
May inquire when you're ready.
Thank you.
A whole army? Petty paralegal? Petty paralegal?
All right, Sergeant
A
Corbett,
one-woman
can you spell
army.
your name, spell it for the record?
Certainly, it's Christopher Corbett, and it's Corbitt.
Okay, I know you've provided testimony a lot of times in this court, but just for the record, can you tell us where you work and what you do there?
Certainly, I'm a sergeant with the City of Tallahassee Police Department, and I supervise the technical operations.
Okay, and we're not going to be asking you for any opinions today, I don't believe, but just for the record, have you been qualified as an expert previously in the field of historical communication records analysis?
Absolutely
about
a
how
road
many
trip.
180.
Sorry, wait. Adam's whole life is a road trip, and I am a gypsy by default. I'm just stuck in this little box doing 6:30 till 3:30 every day of my motherfucking life, getting up at 3:30 in the morning. I can't anymore. Adam, save me.
All right, so I want to go through a few different things that we see in your summary quickly, or types of things. One
Oh,
is gonna be
thank you,
call detail
Tiff.
record summaries.
Thank
The
you.
next is going to be the plotting of location. The next is going to be, I want to touch on your route, something that came up earlier today. And the next is going to be emails and texts. For summaries, in this case, did we receive phone records for Wendi Adelson, Charlie Adelson, Donna Adelson, Harvey Adelson, Alfredo Garcia, Catherine Benoit, and Louis Rivera?
Yes,
And did all of those phone records come from each party's respective carrier or phone company?
they did, yes.
Were each of them accompanied by a certification of business records?
They were, yes.
Are the phone records in this case voluminous?
Yes.
I mean, about how many pages are we talking about? Or just, I mean, hundreds, thousands, something like that, ballpark.
Ballpark is in the thousands. Just one set of records for Charlie Adelson is 4,400 pages, PDF pages.
Oof.
There's probably around 190,000 records that if you put to pages, approximately maybe 8,000, and that's, I think, on the low side.
In the summary that you prepared for the state and a copy of the
Summary.
defense, which is the same copy that you were deposed on a couple weeks ago. In your
I'm gonna
summary,
use the
you
code.
Narrow the party's communication events by focusing on what law enforcement sees as significant days in the planning and execution of this murder.
Yes, I was.
Now, in the presentation, do we see call detail record summaries of communication between the parties?
You do, yes.
All right, I'm going to mark this as states one. I've shown it to defense counsel. This is just an example of one of the slides that shows the call detail record summary.
Yes, it is.
Okay. And if I can publish to the court.
Is there any objection to this exhibit?
No, Your Honor.
It is admitted as a part of this motion hearing.
Thank you. All right, so in your presentation, do we see several call detail record summaries, just as we saw in Exhibit 1, throughout the presentation for the parties' communication on significant dates in the murder?
Yes.
All right, is Exhibit 1 an image of how those look?
Yes.
Is that how they look, though, when you get them from raw records from the phone company?
No.
What do you do to make them easier to read and put them in that format? How do you do that?
First and foremost is assembling all of them together into one database or one pool of information. We will assign names or subscribers to the numbers so that we can recognize which party is speaking with which party. We have to evaluate each of the events to determine if they are valid communication events or if there may be routing events or voicemail events, and those may or may not be included. We would remove duplicate events in a summary like that. If two parties or two subjects are speaking to one another, we would have
Absolutely,
both of those
Pat.
events. From one party's record, it would be outbound, the others would be inbound. So we would eliminate one side of that so that we could show that it was one communication between the parties, and then it would be assembled in something that's much easier to understand and read, which is the format that you had in your exhibit.
After each one of those call summaries in the presentation,
Is it just me, or does everybody want to run their hands across the top of his hair just lightly, just to see what that feels like? I bet you it feels like a puppy's tummy. Maybe if it was a bit shorter. Adam's hair must feel like a puppy's tummy. Oh, wait. Oh, I'm a professional.
or
Oh, also, in case you're wondering, yes, it is 2:50 in the afternoon on a Sunday, and I am having a wine, a bloody big one. I didn't have any wine last night because I was basically unconscious, and I was privileged to be a part of Rabbit and Adam's creative juices flowing on a private live stream together. So I didn't have a wine, and today I am making up for it with an early one.
after most of them rather, are there slides that show photos of the parties with arrows depicting the communication and then showing who communicated with who, the time that happened, and the amount of time they spent on call?
Yes.
Okay, and what I'm going to show you, or what I'm showing you, I'll label as states 2. Is states 2
Absolutely, Pat.
how
Absolutely.
an example of how those, I guess like a chart of the phone communication looks in the summary?
Yes.
All right, this time I move states 2 into evidence.
Any objection?
No objection.
States
Stop
two
it.
submitted at this time.
May I publish to the court at this time?
You may.
Now this chart is the head
Is-
that has the data about the communications. Are all of those charts that appear in the summary, are all of those based on the data that we see in States Exhibit 1, the call summary? So are they based on the call summaries for each of those specific charts?
They are based primarily on call summaries. Some of those would also include maybe text messages from
I'll let you know,
another source,
Chief.
an iCloud return or a Cellbrite report. There may be calendar entries and things like that, primarily from the call detail summaries.
Okay, meaning that that's going to track
That's
communication, whether it be a text or an email, that occurred between the parties.
That's correct.
And then you're saying that some of the charts with the heads and the arrows, when it contains the content
Fuck
of the
yes.
text, that content would be from a Cellbrite report.
It could be, yes.
Okay. Regardless of whether it was from a Cellbrite or from the call detail records, is all of that communication in those charts from voluminous records, whether it be from a Cellbrite or from a call detail record from a phone company?
Yes.
But meanwhile, straighten your
For some
tie,
of the
Mr.
communication
Corbett.
events, I'm now going to move on to the location data. For some of the communication events in the call detail records that you told us about are these voluminous records from the cell phone companies. Were you able to determine location data for some of those events?
Yes.
All right, and
He's like, fuck this shit. I don't want to do this again. Are we doing this again? Jesus, why did they just try them all in the same trial? Because it's strategic and Georgia knows what's what and she has a plan and she is sticking to it. And that's why she is the queen. Queen Georgia, all hail.
I know you've
And all hail Princess Sarah, of course, the dream team.
given the court explanations in the past of how you do that. Judge, do we need to talk through that today?
Just briefly, so it's
Okay.
part of the record for the motion here.
Thank you. Would you give us a brief summary of how you do that
How I determine locations.
from call detail records?
So the call detail records themselves will generally contain, for most events, the location information in the form of the cell site or cell tower that the handset is communicating with for that particular event. From that, either directly in the records or from another key or cell site database, we would be able to determine the location of that cell site, where it physically is, plot that on a map, and then start to make some determinations about location. Generally, historical cell site analysis is about inclusion and exclusion, given locations, places, times, and ask if a handset could be consistent with being at that location based on the cell site that it's communicating with, or inconsistent with that location. In addition to the cell site, we're also generally
100%.
provided a side or sector of the cell site. Most of our cell sites are broken down into multiple sides, and so that helps us kind of further narrow down where a handset may or may not be.
How does your specialized training allow you to determine the location of a handset or the distance from cell site of a handset that a layperson might not be able to?
There's obviously a significant amount that goes into that. First,
Yes to Corbett. I'm here for Corbett, Stanford, and Isom. Let's do this. Let's do this. Bring this on. Oh my God, I couldn't froth any harder about this trial if I tried, honestly.
foremost,
Karen-
locating the
Karen Reed was a mere distraction for me, and I am behind the Free Karen Reed movement all the way. And I'm very much an activist and an Australian spokesperson for Karen Reed and for the bringing down of corruption if possible. But this case is wild.
the cell site, determining the accurate sector or side, determining the width of that sector or side, how many degrees or how far across,
Kenzie!
so to speak, that sector might cover. Evaluating adjacent cell sites or nearby cell sites to determine what the appropriate effective coverage area of that cell site may be, taking into consideration topography, buildings, bodies of water, other things that may affect that radio signal. And then again, ultimately determining if I believe that a handset could have been at a particular location at a particular time.
When you determine, or when you are able to determine location of handsets, do you plot the cell sites on a map showing the cell sites, the time that the phone was communicating with that cell site, and the sector that they were communicating with?
Yes, sometimes we don't need to be as granular as the sector, and so sometimes we only plot the cell site itself. That may be good enough for the point, or there are times, yes, that we will indicate the sector as well.
Okay, and do we see those maps throughout your summary?
You do, yes.
All right. Do you use other things besides just call detail records to help you determine the location of a handset or who may
Yay!
be operating a handset?
Thank you
at the
for
time of
being
certain
here.
communication?
Yes.
Okay. In this case, did you use, let's start with
100%,
are there some examples
Pat.
of text in this case between the parties that helped you form an opinion on a party's location?
Yes.
Okay. Are some of those examples, if Charlie McVanois and Catherine, I'm sorry, Charlie Adelson and Catherine McVanois are making plans to meet up, and do you help, or do you look to that text message to help you determine their location when you then look at the call records and maybe see evidence of a meetup?
Yes, absolutely.
Okay. Or if you see a text message that says outside your house, can that help you determine a party's location when you're looking at the call detail records to see if their location is also consistent with being outside the person's house?
Yes.
In the summary, we also have, in addition to text that has location data, we also have traffic tickets, car rental agreements, GPS pings of a rental car, premier gym still shot from footage, bank records of Rivera showing a picture of him at an ATM. I guess for some of those, I guess like a bank record, could that be part of a voluminous record as well?
Yes.
Some of those arguably not part of a voluminous record, like a traffic ticket or a rental car agreement. Would you agree with that?
Sure.
Okay. Why were those included though in your presentation? All those things that I just named, in addition to the text with location.
Again, the cell site analysis is about locations and times. So, for instance, the rental car agreement for the first rental car provides a location and a time. It's an address of the rental agency and a time that the car was rented. So this allows me to take that location and time and compare to the call detail records. I can look at the locations of the involved parties to determine who was present, who drove to the rental car location, who did not. The citation afterwards, the location of the citation tells me that Mr. Garcia was in a different location than Ms. McManula because we don't have Mr. Garcia's cell site locations in that time frame. So the location of the traffic ticket helps me understand that after the rental, he went somewhere different than she did. Helps me understand that at the time of the rental, where other parties were. Mr. Rivera was still at his home. Mr. Adelson was nowhere near.
I feel you, Kenzie. Time zones are wild. I think Adam feels you also. His whole world has shifted to be like a weird Twilight Zone Australian time, which is nice because normally I'm adapting, nice for me. Normally I'm adapting myself to US times. So it's nice that someone's shifting their schedule for little old me, Miss Shorty.
So we can determine again who is present because that rental agreement gives me that location and time to compare records to. It's also the type of event. So it's picking up of a rental car. And so as we look at the call detail records and who may be communicating with who in that time frame, understanding generally how car rentals are conducted, knowing that Mr. Rivera or Mr. Garcia ends up with the vehicle, Ms. McManus takes it out there, it's presumable that they're both in the car together heading to that event. So I don't expect really to see communications between them, nor I might not expect to see communications between Ms. McManus and Mr. Adelson because she would be in the company of Mr. Garcia. And then I know the date and time that the rental actually happened, and I would, from that, deduce when they separated. And then I start to see communications from Ms. McManus to Mr. Adelson, because now, again, based on how a rental car generally happens, she has dropped him off, he has the vehicle, and now she will be by herself in the car and free to communicate. So all of that together goes into the analysis, if that helps.
Okay. Does the documents that you just spoke about, along with the other car rental agreement and traffic ticket, GPS ping, the premier gym footage, the ATM picture, do those documents help you determine cell phone location and help you form your opinion on where the cell phones are and who was using them and put the communication around them in contact?
Yes, they're all locations and times that I can compare the records to. It's a validation of the records themselves. When I see someone in a picture or a video, I expect that their handset locations would be consistent with that. And if they're not, then there was an issue. In this case, they are consistent. So that's a validation of the records themselves. Yeah.
Okay.
So I can't remember if we've covered this yet. It could be coming, but apparently there's conversation in one of the wiretaps, I think, where Donna, yes, it's wiretaps. No, it's a text message from, so I guess Celebrite, where Charlie, before Charlie's, it was after Katie was, and Sigfredo had already, and Luis Rivera had already been charged, tried, and convicted. And then there was something in the paper about, or in news media about one of the hitmen, I can't remember which one, being a drug dealer. And so there's this text exchange between Donna and Charlie about the fact that that this was the new thing. And I think we've already gone over it actually, but so the state's perspective is this should be allowed in because it's evidence that that while if supposedly excuse me, the conspiracy the extortion thing was all fact, if they'd been extorted, then why would they be gleefully text exchanging that that there was this possible other evidence that perhaps there was a coke deal gone wrong, that Dan had not paid for his coke, and behaved in a manner as he did with all of the other people with whom he interacted. In other words, like a dodgy fuck, which is not Dan Markel at all, nor was he a coke. Come on now, Mr. Kosher Food at his wedding is not a coke addict. So I'm pretty sure it was allowed in. We might not have gotten to it yet. I can't remember. I've watched this stuff about 4 times, all of these. So we'll see. But that's that. I don't know if they haven't, defense haven't revealed their case in chief, because that's not what they'll do. I feel like they're going to go with the extortion thing still, but perhaps this is a secondary, some other dude defense. We shall see. But that's that. But the defense didn't want these messages allowed in, and prosecution were arguing that it was supporting of their conspiracy, because if they had actually been being extorted, then why would they care that he was another throw off that took them theoretically out of the mix, the Adelsons, as being responsible for this murder?
I was briefly going to touch on the routes, but now I'm remembering that that objection was withdrawn. Is the court requiring any questioning on the software he uses to route? Okay, thank you.
You may lay any record, though, you think is necessary.
Okay, at this point, I don't think any is necessary, but if it comes up later, we can. Emails and text are the next things I wanted to touch on. In your presentation, are there several emails involving statements by Donna Adelson?
Yes.
Were all of the emails provided by Google, which is the company that Wendi Adelson and Donna Adelson use to service their email?
Yes.
Does that contain a business record certification?
It does, yes.
Now, why were the emails included in this presentation?
They were included to illustrate the content, and as far as potential motive or events that were occurring at particular times during the investigation.
Do the ones that were chosen involve Donna Adelson's interest in the custody battle and motive in this case?
Yes.
Are the amount of emails in this case from Google voluminous?
They are, yes.
Exactly.
About how many emails would you say that there are?
Wendi Adelson's account has over, I believe, 87,000. Donna Adelson's account is over, I believe, 57,000 individual emails.
Okay. And I'm just looking for a ballpark here. In your draft of your presentation, the same one you were deposed on, about how many emails did we send to defense's emails that these are of interest to us and we may use in your presentation?
No more than 25.
Okay. Since then, have we been able to kind of whittle those down to a smaller number?
Yes, we have.
Maybe 5 or 5 to 10?
Definitely less than 10, I think 5 or 6.
Okay. But despite how many we use in our presentation, are all of those from voluminous records?
They are, yes.
As far as, we also have several text messages in your presentation that don't have anything to do with location. Earlier, I asked you about texts that had to do with location, like let's go to your house tonight or outside your house, things like that. Are there several texts in your presentation that are from Charlie Adelson's iCloud or the cell rights from the phones seized in this case that don't have anything to do with location?
Yes.
All right, not going to go through them all, but just some that are going to be included in your summary. Just some
Yum, Tiff.
Donna Adelson's
Yum.
interest in Wendi Adelson's custody battle and venting to Charlie Adelson about that.
Yes.
Are there some that push back on a possible extortion defense?
Yes.
Are the total amount of text that we have in this case from Charlie Adelson's iCloud or from all of the parties' cell rights, are those voluminous?
They are, yes.
About how, ballpark, how many?
I believe from Ms. Adelson's phone, there's over 10,000 WhatsApp chats, 20-some thousand instant messages. Charlie Adelson's iCloud account is, I believe, well over 280,000 messages. Another probably 10 or 20,000 text messages. They're kind of categorized separately, so we're in the hundreds of thousands of messages.
Okay, and thank you for clarifying that. So when I say text message, I mean any message communication as far as text, instant message, or WhatsApp. So thanks for clarifying that. And so that we've gone from, and how many would you say we've included in your presentation to show the jury at this point? I
haven't counted. There may be less than 20 chats with, maybe, I would probably say less than 50 actual messages. Again, I have not tallied those up.
All right, but from tens of thousands to less than 50?
Yes.
Okay, and those are all speaking to specific issues in this case?
Correct.
Okay. Those are all my questions I had for him, Judge. If you wanted to, I can address any specific slide or document that you feel I didn't ask enough about that you need more of a record on.
Mr. Rauschbaum, do you have an examination for the witness?
Very, very briefly, Your Honor. So, good morning.
Good morning.
So you testified that with regards to these detailed summaries, there's thousands and thousands of pages, right?
That's correct.
Okay. But on the days that you're using, so in other words, I think Ms. Dugan showed you Exhibit 2, where you're doing the arrows. On those days, if you look at the call summary, it's less than 5 pages, right? Mostly 2 pages on most of those days.
For those days, the summary that you have may be a page or 2 pages. It took a significantly greater number of pages to get down to those 1 or 2, because again, if there's 5 or 6 subjects in that one summary, well, that's 5 or 6 subjects worth of records. And they're records for a 3-day, 5-day period, maybe 20 pages each. So there's 100 pages to work down to get to just the unique communications that populate that 1 or 2 that's in the summary.
So let's get a little granular, okay? So you have one of those days is July 18, 2014.
Yes.
Okay, and you do a summary of that day. If you took all your call records of that day, would it surprise you? All of them. If you took the call records for Charlie Adelson, everyone you got, would it surprise you that it's under 15 pages?
For one day to be under 15 pages, it would not surprise me.
Right. Well, I'm telling you, it's under 12 pages.
Okay.
That surprise you?
No.
Because that's not that voluminous, right?
But that's 12 pages to get down to one. Right?
I get it, but I'm saying if you're putting in a document, in other words, if I use the emails as an example, or the text messages, Ms. Dugan brings up that there's 20,000 text messages, or actually 12,776 text messages. You can take my word for that. You're only using, though, let's say 8 text messages. I don't know what you're using, but let's say it's 8. How long are those 8 text messages that you're using? They're less than a page, right, each?
They could be, yes.
Okay. The emails that you're using, you've got however number of emails you're using here. Wendi Adelson's email account had hundreds of thousands of emails, I presume, right?
Yes.
Okay, but each email that you're actually putting into evidence, do you know what the longest email is of the ones that you're putting into evidence in?
It would depend on how you format to print, probably not more than 4 to 6 pages.
Yeah, it's 6 pages, right? So the actual piece of evidence that's going to go back to the jury, which is the actual email, not the 100,000 irrelevant emails that no one cares about, but the actual document that's going to go back to the jury is 6 pages long, right?
I would agree with that, yes.
Right. So we're talking about, and Ms. Dugan uses the word summaries, but these aren't summaries, right? These are just taking pieces of evidence that are already going to be in evidence and sticking it into a PowerPoint presentation, which is a way of persuading, right? A demonstrative, not a summary.
I would object to argumentative.
Sustained.
Okay, I'll move on. With the location data that you're talking about, just centering on Donna Adelson, and I don't know if you have your records up there, so I'll just show you a page. Okay, we can mark this as Defense Exhibit 1 for purposes of this hearing. And this is page 271 of my version of your exchange. You'll notice it.
Yes, sir.
Judge, may I approach?
Right.
So your expertise in doing this page, am I right that what you're basically doing is you're taking Donna Adelson's call record, you're seeing when there's an event, you're looking at what location on the call record the event hits, you're then going to a map that AT&T provides you, it's AT&T in this case, you're then looking what the longitude and latitude is on that map, and then you're just plugging it on that piece of paper, right?
That is part of what I do, yes.
On that piece of paper, is that what you did?
Yeah, just say the sergeant.
No, I don't think so. Again, to start that, I have to go through, and this is combined. This is Donna Adelson and Harvey Adelson's records. So it's 2 sets of records. So I go through the records to find the relevant time frame, and there's 3 data sets for each set of records. There's voice calls, there's data sessions, and there's text messages. So I isolate out each of those 3 data sets for the 2 sets of records. And then I have to evaluate those records for what I consider to be valid location information. And so a number of records are eliminated based on my understanding and knowledge of AT&T records. A lot of those locations are eliminated so that I have valid locations to plot. So from that, each of the locations in the records have to be verified against a records key or some other database for me to make sure that the information provided in the records is accurate. And then that is plotted onto a map. And then from that, some estimation or determination about where the handset was during those events can be made.
Okay, let's try to simplify that.
Yikes. Yikes, JC. Yikes.
When you say you eliminate events, you eliminate them, for instance, when it says
I'd
0
like
seconds,
75 grand
Correct.
monthly. I could do
0
a
seconds
bit of
could be a factor.
Rashi.
right? Why else do you eliminate? What duplicates, right?
In location information, the duration may play into the validity of data sessions. In particular, with these records at that particular time, not all the locations contained in the data sessions are accurate at the time. So I have to go in and evaluate each one of those to make sure that they are the correct usable locations for that. And
Not money well spent.
I guess I'm not the one to determine how much expertise that takes, but I believe that it certainly requires it.
Well, on that piece of paper, which is all Donna Adelson's, everyone that relates to Donna Adelson looks like that, okay? So on that piece of paper, would it surprise you that all you needed to do for that piece
I
of
would
paper?
object to relevance to what would surprise him.
Sustained.
Okay.
Please
I would phrase it. On that piece of paper, you can see those times directly on either Harvey Adelson or Donna Adelson's chart. You see a call or a text message.
Yes,
You go and you look at what time it is, right? It says 8:15 next to the call.
correct.
And then to the right of it, it gives you a longitude and latitude
It does.
for each of these. And then you take an AT&T map and you plug in that longitude and latitude, which is what you did, right?
Well, I don't take an AT&T map. I take the mapping software that we use, the Esri mapping.
Fair enough. You plug in that longitude and latitude and it spits out a point to put a dot on a map, right?
It does.
And so even though it can be difficult, I'm not saying that there aren't examples that are difficult. In the ones that you're doing for Donna Adelson, it's on these pages. It's as simple as that. It's as simple as looking at the data, plotting it in, and doing dots.
Again, I don't know that I'm the one to quantify what is simple or difficult, but I will tell you that if you took her records and you plotted
Literally.
every event in that time frame, you would be plotting some incorrect locations. So it at least requires the recognition of valid locations at the very minimum.
So tell me, on that piece of paper, what events were invalid that you got rid of? Because I don't think there were any invalid.
I just want to straighten up his tie, Corbett's tie. He looks rough around the edges, the poor man. This case has broken him. It's dragged on for so long. Yoinks a doinks.
Yeah, on that piece of paper. I don't think there are any other cell site data that showed up. I think those are the only ones that showed up.
In that sequence, that
Yeah.
travel sequence, in those
Tell me what
period
you eliminated.
time, there are a number of data sessions, and I would have to be looking at the records themselves, that are continuous data sessions. And so they show locations, particularly from Mr. Adelson's cell phone, as I recall, of data sessions that originated at his office. And those data sessions continue to show the original location, even though the times increase. And so
You're talking about Charles Adelson.
I'm talking about Harvey Adelson.
He showed him at his office on that day?
It did, yes.
On July
I
18th?
remember that
As I
part.
recall,
Are you
I
sure about that?
don't want to say office. There are, if I look at the records, there are data sessions that originated earlier in the day that continue to show the original location.
Okay, let me ask you a more simple question. On the actual exhibit that you're using, which starts at 8:15, I think, it plots, I think, 4 locations. On those 4 locations, were there any?
So they had 10 million in the bank, apparently. Their net worth, no, they had cash money, 10 million in the bank when at the time of the murder. So yeah, they probably could have bought their own island here. You could have been the peer on their island. It's going to be a no from me. No from me. Nobody wants to be anywhere near that Adelson Island of death.
Anything that you had to
Evil.
eliminate in between those 4 data points?
I don't recall specifically. I can look at the records and tell you, but I do not recall if there were other things.
Well, do you have the records in front of you?
I have my laptop. I can pull them up. It will take a minute, but
Sure.
Go ahead.
Judge, while he's getting his computer out, the court, my memory serves me, it seems like this line of questioning is Mr. Ashbaum's trying to inquire into his level of expertise and why does it require an expert to do this type of work. Did the court already, I believe the court already ruled at our last hearing that he would be able to testify as an expert, form an opinion as to locations of cell phones, all of the things we'd be offering him for in that purpose.
That ruling was made. Ultimately, is this going to an opinion that he is not permitted to give in some way, Mr. Ashbaum?
No, I mean, I'm trying to show that there's no expertise in these particular documents. There might be in showing where, say, Fredo Garcia's timepiece was, but that there isn't expertise with regards to Donna Adelson's. And I'm going to using this to show that the documents that he has chosen here, or that the state has chosen for him, that it's a demonstrative. It's not a summary exhibit as iterated under the Florida statutes. I mean, again, we're not arguing that the demonstrative can't be used, and we're not arguing that the underlying documents can't come in. We're arguing that his presentation is not a proper summary, but is rather a closing argument that shouldn't go back to the jury.
And so that point, I'll permit it, but let's not have a full cross-examination of the witness that goes beyond the issues as to the admission of the evidence.
Fair enough, Your Honor.
Everything they do is dumb, Shiraz. Bloody fools. Entitled idiots. The takedown is real and I'm here for it. We're here for it. He's still at the airport, Tiff, right? He never found his way out. That purple, mate. Donna's purple.
It's difficult to pull up.
Mwah.
it will be a little time consuming again.
Let's move on. I think we've made the point. Sergeant Corbett, these emails and these text messages that you pulled, how were they chosen? Did you choose them?
I did not choose them, no.
Who chose them for you?
They were ultimately chosen by the state attorney's office.
May I have one moment, Your Honor?
Go ahead.
I have no further questions.
Any redirect examination for the sergeant?
No, sir.
You may step down, sir.
Thanks, sir.
In addition to the argument that was made at the previous hearing, does either party have any additional argument to offer before the court rules?
Corbett's like, get me the fuck out of here. I'm out. We out.
Whoever's ready.
Everett, we out.
You are the proponent, Ms. Dugan, so you get the first crack.
All right, so we heard about several different types of items that are in the summary.
It's all right,
The
Scott.
first
You can
summary
say
is
whatever
CDR,
you
for
like
example,
in my
states
chat
one. We heard that there's
anytime,
reports from
sir.
voluminous business
You
records
are
for
a
certain periods
gentleman
of
and a
time.
scholar,
Then we saw
and we love
the
you.
charts that are basically a visual depiction of that communication that's in, but in a more digestible format for the jury. It's based on data from those call detail records, from the voluminous business records, and also from voluminous records in Cellbrite. The only thing in the chart that is from Cellbrite would just be some charts have contents of text messages in there. All the rest are going to be calls back and forth with the.
Sorry, guys. I think maybe I'm going to have to start wearing suits and push my sleeves up because I'm frothing over Sarah Dugan. Is it possible that I'll turn gay for Sarah and Georgia? Highly possible. Look at her. She's a queen. She's the queen in waiting.
with the time and the person making the call and the person receiving the call. But all of that information is based on the data, and we can't just give the jury all of these cell phone records and say, even if a certain day is 16 pages across 3 sets of records, and say, good luck. That's why the summary rule allows us to pull this information, put it together in a digestible format for the jury. The second type are the maps with the cell site locations. These are summaries of the parties' locations at certain times that are also pulled from the voluminous cell phone records. The same records that
Yes.
the call detail record summaries and the charts with the heads are pulled from. Other items like the premier surveillance footage, the tickets, the texts that talk about a person's location, the bank records, the car rental agreements. All of those things are in the summary because they help Sergeant Corbett form an opinion on who had the handset at the time and where that handset was located. And they help verify the call detail records themselves. Finally, we heard about emails and text messages. The emails are business records from Google. These are voluminous records. They're being testified to by a sergeant who specializes in communication records. He has identified and verified these as being from these accounts. There are thousands of emails. We found several emails, lots of emails that go to motive or go to the interest in the custody battle here. We're going to be using about a handful in the presentation. The same with the text. These are maybe 50 texts narrowed down from hundreds.
We've got about 12 minutes left on normal speed, so about 10 minutes left on 1.25 or 1.5. So we're almost there, y'all, and then it's Wendi. Does anyone know if Wendi is being televised? I hope so, although there's no creepy Josh Dubin to do that. Creeping on our Georgia. Get your dirty, filthy eyes off Queen Georgia, sir. Sir, yuck.
Hundreds and thousands that show certain relevant issues from this case, whether it be pushback on extortion or other things. And these are all pulled, though, the emails and the texts that aren't location data is what I'm talking about. They're all pulled from voluminous records, and they're all a summary of evidence showing a relevant issue from
Thanks,
the voluminous
babe.
records. Thanks.
Thank you. Mr. Rashbaum.
Judge, you've seen their summary. Their summary is a closing argument. It's not a summary. It's a demonstrative. Our ask here is not a big ask. The underlying.
Maybe it's the wine talking, but I'm here for George's pantsuit also, Shiraz. So I don't know. There's something to be said for a strong, sassy, smart, classy, gorgeous woman doing what she does best. Tiff, I don't fight. I'm a lover, not a fighter. There's two. There's Sarah and Georgia. We can just like tap in, tap out. Aye. Maybe it's the 3 o'clock wine talking. Jeez.
Underlying exhibits are going to go to the.
Needless to say, none of us are trying to vie for Rashi. That can be sure. We'll take the bailiff. I'll take Judge Everett before I take Rashi. Mate, I'll take Madam Court Reporter right there looking stern. Rashi is the lowest rung on the hot list ladder.
To the jury. They're not voluminous. The fact that there's a universe of text messages and they've chosen 10, 15, or 20 of them does not mean that they can make a summary of it. That's not how the rule works. They can put in the text messages, none of which, not one text message is voluminous in this case. Not one email is
You do you, Boo, Scott. You do you. We love it.
What they're going to put into evidence are they're going to put in the overall call records, and then they can put in, if they want, a subset of the call records. For instance, July 18th. They can put in those call records. They're literally less than 12 pages. Now, we're not suggesting that Sergeant Corbett cannot have a demonstrative that illustrates the issue, but to allow a 320-page document or whatever it's going to turn out to be, which is purely argumentative. I mean, they're taking text messages and homes and cell locations, and they're all.
Yeah, I will literally fight you for the
precisely
bailiff.
what the court
I
incorporated
wouldn't, Adam. I wouldn't.
378 F3rd 1154 cautioned against. When it said, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. That's what they're doing here, Your Honor. They're putting a closing argument. They're trying to put his demonstrative as a summary exhibit of a closing argument to go back to the jury. That shouldn't be allowed. And so, Judge, we're not asking that a demonstrative not be used. We're not asking that the underlying documents don't come in, but we're asking that the exhibit be a demonstrative exhibit, that does not go back to the jury.
Can I briefly respond, Judge?
So briefly, it will tickle my ears and we'll move on. Go ahead.
There are no
Judge
arguments
Everett.
in any
He's
of
a
these slides.
darling.
This is all data and information from the records. There's plenty of evidence in this case that is not in this presentation that would be in a closing argument demonstrative. This is not a closing argument demonstrative.
Judge, may I briefly respond?
Let me set my watch. It's 11:02 and 32 seconds. By 11:03, you will be done.
Argument,
Yes, you
argument
will,
is when you
Rusty.
plot lines on a map, and then you take a text message and you put it next to a house, and you put it all together. That's argument. That's using data to make an argument. That is the definition of argument.
Good job, Rashi.
Thank you.
Your Honor.
All right, as to the rulings on this matter, the court has previously ruled that Sergeant Corbett can be qualified to testify to the interpretation of historic communication data. The summary will be available to the state as a demonstrative in front of the jury. Also, in researching this matter, I came across a recent case of the 3rd DCA dealing with summaries, which I believe has a relevant ruling to this matter. This is EJD Construction Contractors and Investment Corporation versus Preston, found at 306 Southern 3rd 1053. And ultimately, the 3rd DCA held when a summary is accurate and not misleading, it can be properly admitted.
Sorry, but for 75 grand a month, I'd be giving it everything, mate. I'd be doing naked upside down cartwheels and handstands for 75 grand a month. Yikes.
During trial, the summary may also include opinions by the individual preparing the summary, as long as the opinion is based on the underlying evidence and data that is admissible. To that point, the court will permit a summary to be admitted to the jury. However, the summary may include a page cross-referencing all voluminous records or state exhibits that Sergeant Corbett used in forming his opinion, his method of analysis, and the conclusions that he reached, or any inferences which may be properly drawn from the evidence. The summary is not to include any cumulative repetition of admitted state exhibits, and this is specifically going to matters such as the emails, text messages, videos, things of that nature, any inadmissible information or any opinion the witness is not qualified to give. This is going to cut down the pages that actually go back to the jury, but a summary that is based on the voluminous records and exhibits and the opinion that was reached by the sergeant that is proper and meets the definition of a summary pursuant to 90.956 will be permitted. Any additional objection that needs to be raised at the time it is offered, the defense may raise at that point. The parties need any clarification on the ruling.
I mean, it's not really something anyone would want to see, Scott, but I'm for 75 grand, I'm down.
And just so it's clear, as far as the call record summaries, and I believe the arrow charts, those will be permitted as far as being in the summary itself. The location maps, that will be permitted as well. Again, all of the other matters that are not voluminous themselves, such as any emails, text messages, or videos, it can be cross-referenced as to what the sergeant used, but it will not be a part of what is admitted. The demonstrative itself, though, can be used as the state would like to use it. Ultimately, for that, if there are any
Needless to say, Karen got absolute and continues to get value for money. Donna, not so much. Sorry, Donna. Make better choices in life and in who you choose to represent you. Mostly in life, because there is not, Alan Jackson can't get you out of this one, mate.
inadmissible items that still need to be ruled upon. I believe slide 20 is the only one outstanding. I will give you a ruling on that matter before it is to be used even as a demonstrative. There are no questions. We are finished at this time. I will see everyone on Tuesday morning at 8:30, and we will begin with the jury selection process. The process will be, as we did in the last trial, going through the same 5 questions dealing with pretrial publicity and any hardship. The parties will be permitted to examine the prospective jurors based on the court's questioning. Anything that we need to address before we finish?
Judge, there is just one scheduling issue. And look, maybe trial will go quicker. I'm hoping it does, but based on what I'm seeing, October 3rd is Rosh Hashanah, the Jewish holiday. And I just want
I
to see.
believe the court's closed on that day.
And sit down now.
Sit your ass down,
I'm not gonna make you
Rashi.
work
Snip
on
your
holidays,
fingers.
Mr. Rauschenbach.
Snip your fingers.
Yes, ma'am. For Monday, let me go through that then, based on the chart that I have in land. If it's not related to this, then we're just going to finish up. We are in recess at this time. Have a good day, everyone.
I was coughing. Coughing. Too many vapes. We out. Oh, Georgia. Oh, Donna. How about them there shackles, those cuffs and that belt? Suck it, Donna. Couldn't happen to a nicer person. Scott. 1:27 a.m. Scott is a little bit saucy. Oh, whoa, law and crime. So that's it. That's it, guys. Idea. Bring that shit on. That's how you say it. Jury selection. I'm not sure if it's televised. If it is, I might do a little recap. Got some good ideas from you guys. We need to see if we can find out about her commissary budget. and also her jailhouse menu, because I mean, all I can say is I think maybe Donna wishes she'd gotten that facelift before she tried to flee to Vietnam. And I mean, she was severely underweight before, so maybe she's just looking as she should, and perhaps she's feeling a little more healthy. No. Thank you so much, y'all, for being here. I love that you've been here. Thank you, Adam, for flying the flag in the Camp Shorty ship. Thank you, Shiraz, for the coffees. I really appreciate you and that generous support. Check out my playlist. I have a full Justice for Dan Markel playlist full of shorts. Mwah. And it is my channel life's work. I put a lot of time and energy into that playlist, and it's fun. It's a fun reminder of all the mic drop moments. If you've got an hour and 20 to spare, it's 86, 87 shorts. And plenty of fun there. I will schedule some stuff when I know what's happening, and we'll go from there. So they estimate that jury selection will take a couple of days. It did last time, but that was with Josh Dubin. He's disgusting, such a creep. I have a short just for him. Creeping on Georgia, sir. Get your grubby eyes off Queen Georgia. Just not okay. I will cut a bitch if anyone tries to creep on Georgia. Rashi, keep growing that beard, champ. I don't know, Pierre. I will check it out. I don't know about whether they schedule things. If there is jury selection on camera, or I will see if we can find some highlights. I'll try and get some timestamps so we don't have to go through all of the jury questions with all of the prospective jurors in the veneer, but we'll see. Definitely going to be, I'm going to try and do recaps every day, because this is what I've been waiting for. So we'll do what we can do. After the stream has ended, I would love if you could drop a comment in the chat, in the comment section, just to get this out into the algorithm. Thank you so much for being here. Smash that like. Hey, shorties. Mwah. Love your faces. I'm going to go out with Melissa Salem's amazing Shorty, tribute to Shorty. So catch you next time. Sleep well. Thank you for being here. Love your faces.
The United States and Australia are sister lands. All around the globe, we are holding hands. Plymouth Rock to Botany Bay, colonists hope for a better way. Sydney Opera House to Broadway, a testament of who we are today. Oh, still have rent to pay, we still have rent to pay. Braintree Park to Honolulu, Utah Arches to Uluru, Bourbon Street jazz to didgeridoos, our kinship is deep and true. This is how we begin to start atoning for our sin, by creating new expectations for our blemished nations. The Great Barrier Reef to Grand Canyon, from the Everglades to Billabongs, the Cloud Queen cares about everyone. The roller coaster ride is only just begun. Cry, debunk, demystify, destigmatize, uniting USA and us. Uniting USA and us. The world is her battleground, her verbal roller coaster goes around, calling all nations with her horn. She is a shooting star out of Melbourne. Miss Shorty is a shooting star out of Melbourne. Miss Shorty connects and unites, debunking all the lies. She leads us in our fight. She's a fucking delight. Grizzly bears eat hikers who are in a rush, and Aussie dingoes steal babies in the bush. The damn beavers live in the brooks, and so does the weird-ass platypus. From Bondi Beach to Miami, Adelaide Hills to Napa Valley, from Kosciuszko to Colorado snow, Lady Gaga to Kylie Minogue. Miss Shorty connects and unites. Our citizens should be made right. She leads us in our fight. She's a fucking delight. This is her cry. Debunk, demystify, destigmatize, uniting USA and us. Uniting USA and us. The world is her battleground. Her global roller coaster goes around.